Very good experience.
Good outcome?
Not for the state, but a good experience.
Justice was served.
Justice was served.
Okay. This was a retrial. What happened the first time? Was it a mistrial? Was it reversed? Was it?
It was two separate offenses, of rape, and the defendant was found not guilty on one of the counts of rape, and on the second count of 6-6 hung jury. So they retried it on the second rape offense.
And then it was not guilty second time around.
Yes.
Maybe saw that coming.
Yes.
Okay. Okay, we are now up. Let's see, one chat. Mr. Whitenauer, is the audio better now or still wobbly?
Now I think it might be better. Thank you, Judge.
I was slow in signing in, but hopefully it's working now.
Thank you, Judge.
So plea and arraignment, positions 1 and 2 are Mr. Davis. He has waived arraignment. Was he brought over? No, excellent. So the system is working. Gold stars all around. Oh, I'm going to assume Ms. Feely let Ms. Nelson know and he didn't get brought over. Who from the state? He's got 2 very different sets of offenses. Mr. Jordan, I assume you've got position 2.
That's correct, Your Honor.
Mr. Shapiro, you've got position 1?
That's correct, Judge.
Okay, that's an old case.
It is.
So you will get discovery to Ms. Feely on that. Mr. Jordan, you will on yours. And I'm assuming it's going to be Mr. Shapiro's case that kind of moves this along, assuming you can find everyone connected with it.
Assuming that, Judge, yeah.
Okay. All right. Got it. We'll get scheduling order out and make sure the 2 cases move in concert. All right, position 3 is up. Now we're jumping to inquiry and our discovery deficiencies. Thank you for filing those, Ms. Wood. Mr. Trapatis, who is on the screen, and I'll remind everyone, no one asked me to recuse before, but I know Mr. Trapatis from when I was a federal prosecutor. Can you unmute Mr. Trapatis?
I didn't realize I was muted.
Muted you.
How are you doing, Judge McBurney?
Well, my friend, how are you?
I'm well. Just trying to thaw out. You know, being frozen in federal custody for a number of years can have a toll on a person, especially when technology has advanced and you just feel completely slow. So it's a process, but I'm alive and I'm striving.
Good. So Ms. Wood, this was on to make sure that discovery had caught up with you. What is your report? What's missing? What do we need to fuss at Mr. Jordan about, or is all good?
Good morning, Judge.
Morning.
Mr. Jordan did serve discovery on Friday. I haven't had a chance to parse through it and make sure everything is there. And I also share some stuff with him. So I'm thinking he probably needs a chance to also get through with that.
Mutual digestion on both sides.
Yes.
Okay. You have good contact information for Mr. Trapatis?
I do. Hi, Mr. Trapatis. We've been in close contact. I would be fine with this moving forward to a trial calendar.
Okay. And you'll let Mr. Jordan and Ms. Nelson know if there's something fundamental missing. It's an older case. I'm sure Mr. Jordan got you what he's got, but there needs to be something to know, and Jordan can and we'll move it to a trial calendar moving forward.
Yes, Judge.
All right, Mr. Trapatis, doesn't mean that you must go to trial. That's just a trial calendar is a good focusing device that gets lawyers to think seriously about how they really want to work the case out. It brings you closure, because if people can't work it out, then let's try this thing from 2016 and we'll see where it goes. Do you have questions about what we discussed?
We haven't missed the deadline to file pretrial motions if we need to file any, have we?
So the answer is no. The deadline has long since passed, but your lawyer didn't have discovery. And so how could she have filed motions not knowing what's in discovery? So there's a waiver of sorts. If the state has provided discovery to the defense, then there is an exception for late filed motions. So Ms. Wood and you can look at the discovery together and talk about it. And if she thinks that it is in your best interest to file something, a motion to suppress or this or that, she can do so, and we will certainly hear that before we would try the case. Just looking at what the charges are and knowing a little bit about where you spent your past few years, my sense is that and Mr. Jordan are going to be talking about resolving the case rather than about litigating pretrial motions. But I will go along with whatever they come up with, in the sense that if it's going to be motions, we'll hear the motions. If it's a plea, it's a plea. Ultimately, if it's a trial, we'll do that. I just don't want this hanging out any longer than it has to. So I'm not trying to shortcut or short circuit any of your rights. If it's motions, we'll do that. Otherwise, we'll keep trying to move it towards resolution. Does that make sense?
Yes, sir.
Would anything on behalf of your client?
No, Your Honor.
All right. So Mr. Trapadas, you will see me next, either because the motions hearing, like you were maybe foreshadowing, or because we're calling the trial calendar, or option 3, you've worked your case out with the state and you're trying to convince me to go along with that. Okay.
Okay, one last question. I know one of the conditions of my bond is for me not to go to luxury car dealerships. So in the event, like, I know my girlfriend has a Mercedes. So if we're having to go to service, how do I contact the court and get permission to go to, I don't know, Mercedes of South Atlanta?
So I'm hearing you. I'm glad your girlfriend drives in style. It is in your interest, until we resolve this, to have her deal with the service. Just be strong and let her deal with the mechanic. But past place for against Kia. The Mercedes dealership.
Okay.
All right, I think we can manage that. Mr. Jordan, anything else on Mr. Trapadas' case?
Nothing further.
All right, thanks, everyone. Mr. Trapadas, you're free to go.
Thank you.
Next up is Michael Green, who is on for a probation revocation, and he must have gone through drug court, given who the probation officer is. Who is handling Mr. Green's? I know it says Nicole Fagan. I know she's not. I don't believe she's still handling the case.
Judge, I'll handle it if I could have a minute to speak with him.
All right. The warrant talks about some fairly low-grade offenses from August of last year. Do you have a copy of it? Or do you need a copy of the warrant?
I don't believe I have it, but if it's an odyssey, I can pull it out, Judge.
Okay. If not, Ms. Nelson can email it to you, because she emailed it to me. So why don't we hold on Mr. Green and we'll come back to him. And that gets us to Mr. Do you pronounce it Jaluk?
Yes.
Okay. And he is on for discovery deficiency and bond motion. Mr. Whitenauer's case?
Yes, sir.
All right, Mr. Whitenauer, are you ready to address? We'll bring Mr. Jaluk out in just a moment. Are you ready to address those matters?
Yes, Judge.
Your Honor, I realize
that my sole the defendant's attorney, position number 11 in Plum Brinkley, filed a waiver of arraignment.
She did. Why don't we jump to that right after we do this?
Okay.
Because then you can get out of here. If you I'll bring him to the door, I don't know what's going on. I figure you'd be here for that. All right, let's get record in 22 SC 184-222. It's State versus Mr. Do you pronounce it Jaluk?
Yes, sir.
Mr. Jaluk, who is here in court with his lawyer, Ms. Wood. And we've got two things to work through today, Mr. Jaluk. Ms. Wood had filed a notice a while ago that she didn't have discovery in your case. She also filed on Halloween of last year a motion for bond. We're going to talk about both those. I'm going to start with the discovery piece first, and then I'll hear from Ms. Wood as to whether you should either get a bond if you have none or have your bond lowered. And then the prosecutor is right there on your screen, and I will add you to the screen. There you are. Mr. Whitenauer is going to give me his thoughts on bond as well. But let's start with discovery. Ms. Wood.
Thank you, Judge. I did file that discovery deficiency and then discovery was produced shortly thereafter. So I believe I have everything in this case. So we would be ready to move forward to a trial calendar. Yeah, we're
Okay.
ready for trial.
Great. So, I mean, if there's something missing, it's at the edges. It's not, I don't have the police reports. I don't have my client's statement or whatever the core of the case might be. You've got that now.
Yes, Judge.
So we can move past discovery. Other than Mr. Whitenauer, is there discovery you're aware of that you've been able to get your hands on that you will be getting to Ms. Wood once you get it?
No, Judge. Discovery deficiency notice was filed on January 9th. Discovery was served the same day, and that included the medical records for this case.
Excellent. Okay. Then we will move past that and get to bond. Let's see what we've got already in place. I don't have anything about bond.
He has no bond.
What? No.
When you're ready to talk about bond.
Thank you, Judge. Mr. Jaluk is 35 years old. He's originally from New Orleans. He's been here in Atlanta for the past 15 years. Most of his family does reside here. He has 4 children. The complaining witness in this case is actually his significant other, and they have been together since this, or they've been together for a long time and then are still together. This incident is from 2020. He has a 12th grade education. He does have his GED. He's got gainful employment with U.S. National Recycling and Demolition. He's been there for the past 3 years. He can return to that job. He does have a stable address to return to. He has ID, he has transportation. Like Mr. Whitenauer noted, he's been in 150 bond. He's just eager to get back to his life on the outside, Judge. We would ask for a reasonable bond in this case.
Laid a lot on me real quickly. So where is it that Mr. Jaluk would stay if he got a bond that he was able to make that is not, I'm trying to pull up the indictment, but Odyssey is being slow. I assume it wouldn't be with the significant other.
He could stay with his mother at 3658 Mill Glen Drive.
We can get but it's okay. And who lives in the house with mom?
My son.
You've got 4 kids, so one of your kids stays with your mother.
Yes, sir.
With the alleged victim in your case?
No, sir.
Any of your kids with the alleged victim in the?
No, sir.
No, okay. Does she live by herself?
I have 2 stepdaughters.
Okay, she's got 2 kids of her own. She lives with them. with your mom, the we are somewhere else.
Mhm.
Okay. How old is the son of yours who lives with your mom?
Yes, sir.
All right. In, when did you go to school?
Alexander High School in Douglasville, Georgia.
Okay. Your mom's in Douglasville?
Yes, sir.
What's the education you would have? It sounds like you have, but not a driver's license. So how would you get from Douglasville to US National Recycling?
He picked me up. We have a truck that he picks up the employee. I'm working from home as an estimator, sir.
Oh, you were, I don't know what, I was assuming National Recycling Demolition, you are somewhere driving a backhoe or breaking things up.
I've been out of the field for the last 2 years, so I was promoted to be an estimator.
All right, but estimator doesn't mean you go to a site, you're able to do it on a.
Yeah, I do it from home, basically.
Ms. Hollis, now I finally got the indictment up. Ms. Hollis is your, all right. She live in,
She lives in Atlanta.
okay. So if you needed to get somewhere for work, your boss could pick you up,
Yes,
but a
sir.
lot of what you're doing, you can do with a computer or a phone or something?
Yes, sir. Remotely from the computer.
All right. And you've been in Atlanta, I think it was the past 15 years?
Yes, sir.
Okay. All right. Got it. How long had you and Ms. Hollis been in item?
Almost 4 years now.
Okay. All right. Have you been, I'm not asking this to get you in trouble. Have you been in touch with her since you've been locked up?
Yes, sir.
And how is that?
Through phone, talking, conversating.
Does she call you or you call her? I guess they call you.
Well, I call her, sir.
Okay.
But we've been fine. I mean, this incident, I really want to get it over with.
It's from 2 years ago, 2.5 years ago.
Yes, sir.
Got it. Okay. All right. Following it. Mr. Whitenauer, thoughts about bond in this case?
Judge, we're opposed to bond for the following reasons. One, Your Honor, this defendant does have a prior family violence battery arrest. He managed to resolve that case with a plea to criminal trespass in Clayton County. It was back in 2011. He also has a cycle out of Louisiana. That cycle is dated, it's from 2004, but it shows bench warrant out of New Orleans, Louisiana, for what looks like a criminal trespass. And then perhaps more importantly, Judge, is yes, this defendant has been speaking with the victim in the case, Ms. Hollis, since early on in his incarceration at the Fulton County Jail. Of note is that on September 27th of 2022, the defendant was speaking with Ms. Hollis and told her directly, "You tell them I'm not cooperating." Your Honor, so there is some concern this defendant, if released, would not only have the ability to influence the victim verbally, but perhaps physically, being able to have contact with her. In this case, he fractured her nose. There's nothing further from the state.
All right. From pretrial, good morning.
Good morning.
If you have anything different, Mr. Whitenauer was able to share, there was a family violence battery arrest from a long time ago, 2011, and then some Louisiana entries from 2004. Do you have anything more recent than 2011?
No, sir. I'm basically showing the same information.
Okay. All right. Thank you.
Yes, sir.
So, Mr. Whitenauer, you are saying no bond, not bond with an ankle monitor and no contact with Ms. because even though there may have been a no contact provision in place because he doesn't have a bond, Mr. Jaluk has been communicating with Ms. Hollis. I just want to make sure I'm replaying your perspective.
Yes, Judge, I don't think there's any order that can keep this defendant away from Ms. Hollis. He has spoken with her almost every day since September of 2022. He was speaking with her as recently as yesterday in the evening.
anyone from your office communicated with Ms. Hollis to get her perspective on this as to whether she's concerned about these repeated phone calls, or if she has welcomed those calls, if she would like to be out so that he can start earning money again, which would contribute to others, et cetera.
No, Judge, I've not spoken to her about the phone calls, but we have spoken generally about the case, and she has denied being afraid of him, and has acknowledged that she's been in regular contact with him.
Ms. Wood, I don't remember you specifying a bond amount other than bond would be good.
Correct, Judge.
Anything you want to add in response to what we heard from Mr. Whitenauer?
Judge, Ms. Hollis, I've also been in close contact with her, and I had given her the Zoom link. She did have a doctor's appointment this morning, so I'm not sure if she was able to hop on. But yes, she has indicated that she's eager to get out of custody.
Okay. Mr. Jaluk, I am going to set a bond. We'll figure out the amount in a moment, but I want to explain the important part. For the first 30 days that you're on bond, once you make the bond, if you make the bond, you can only have remote Hollis. You can talk to her on the phone, text her, not face to face. If after 30 days, Ms. Hollis, the state, say, I would like to be able to be in the same space with Mr. Jaluk, my daughters miss him, whatever it may be, then we can talk about whether we lighten that up a little bit, and then you could be in the same space with Ms. Hollis. But at least initially while you're on bond, and at least 30 days, and there's one, you can't haul on over to her spot and say, I'm here. It would be after smoothly, then you and Ms. Wood could talk about it, and she could reach out to me and we could have, is it appropriate to let you and Ms. Hollis be in the same space together? So at first, you can call her just like you've been doing in jail. She can call you, do FaceTime, but you may not be in the same space with her. In fact, you'll be required to stay, what the magic number is, 200 yards away, but you can't be around there, and she really can't come around you. If she wants you to spend time with her daughters, through your mom or someone else, you need to arrange a way to get those daughters so you can't be in the same vicinity as Ms. Hollis. Does that make sense?
Yes, sir.
What I'm going to do is set a $25,000 bond through the sheriff's 10% program. And what is that the money that someone puts up on your behalf, whether you do or your mom or Ms. Hollis, most of it you get back when you're resolved, as opposed to a bonding company where you don't get anything back because you bought something. This is more of a loan to an account that the sheriff's office controls, and then most of whoever provided that. It's going to be $5,000 for each count, and therefore that gets to $25,000 through the sheriff's 10% program. You'll be on pretrial supervision at the supervision. East, you'll be required to wear an ankle monitor. That ankle will be funded by the county. You're not going to have to pay for it, but help develop a level that you are staying away from Ms. Hollis, other than virtually. Again, you can call her and write her, but you are not able to be around her, and you'll be able to tell with the ankle monitor, because if you're over where her place is, that's going to cause the ankle monitor company to say red alert, and we'll work from that. So special condition number one of your bond is that you have no physical interactions with Ms. Hollis, and her first name is Tracy, Tracy, Tracy Hollis. Mm-hmm. You can communicate with her on the phone, social media, etc. If she decides that any of those communications are inappropriate, they're threatening or whatnot, and she relays that to the district attorney's office, that would be a reason to revoke your bond. Also, being around her would be a reason to revoke your bond if we get, if the district attorney's office provides me with information that that's happened. I don't know that we need to set up a curfew because the main point is not that you stay home with your mom. It's that you continue to stay away from Ms. Hollis until this case is resolved, or at least we get past that first 30 days. You will be required to reside at your mother's residence. And I'll get that full address from Ms. Wood, but that's the home in Douglasville. And so I guess that's where the curfew would kick in, because I need to know that you're there each night and not wherever Ms. Hollis might be, either her house or she gets a place and you go visit her there. So when you're working, there's no reason that you'd need to be out doing work after 9 p.m. Is that a fair window?
Well, I'm gonna still work from home, but I must, try to go in the field also. So I'll be trying to do both, but I have to check with my boss to see the scheduling. Cause I know we doing a Georgia Aquarium downtown Atlanta, renovating, and I believe that it's after hour work, night work.
Okay. Well, how about this? For now, I'm going to say that you have a curfew of 9 p.m. to 5 a.m., meaning that your ankle monitor needs to show that you're at your mother's house from 9 p.m. to 5 a.m. Now, if you connect with your boss and he says, no, I'm going to need you at the aquarium, we can flip it around. And it would be that you'd have to be at your mom's in the middle of the day. I'm open to modifying it, but I want to start out with some structure so that I can be comfortable that we're not having a repeat of whatever happened in August of 2020. That's the main goal, is to keep Ms. Hollis safe until we sort out what's going to happen with the case.
Okay.
Mr. Whitenauer, any other conditions you'd want?
No, Judge, thank you.
Ms. Wood, anything else about the bond?
No, Your Honor, thank you.
Okay. And Mr. Whitenauer, I assume the victim advocate will let Ms. Hollis know that a bond was set so that Mr. Jaluk could be, but that the conditions of the bond require him to physically stay from Ms. Hollis, although he can communicate with her.
Yes, Judge.
Okay, great. Anything else so we can move Mr. Jaluk's case to a trial calendar?
Yes, Judge.
All right, we'll do that. Thank you both. All right, we're going to jump all the way to position 11, Antoine Brinkley. Was he brought over? If we could just have Mr. Brinkley come to the door. So is Ms. Gordon private? Okay, but she does gang stuff, or?
It's,
What's the mystery?
This case pre-indictment, she's our SB 440.
Oh, right. This is, I looked this stuff up yesterday. I noticed the SB 440. Will she keep it?
She will keep it.
Okay, all right.
Not a waiver.
I'm just going to explain to Mr. Brinkley what we're doing. He's.
Yeah, she keeps it from the start.
Okay, that's great.
Yeah. For our youngsters.
Mr. Brinkley. Hey, I'm Judge McBurney. How are you? I'm just putting you right at the door because this will be quick. Your lawyer is Ms. Gordon. You met her before?
Me, yes, sir.
Okay. So Ms. Gordon's still your lawyer. Your case has now been assigned to me. And Ms. Gordon has filled out all the paperwork to say, hey, Judge McBurney, I'm Mr. Brinkley's lawyer. We're waiving arraignment, which just means I don't have to read to you everything in your indictment. That's going to require the state, the prosecutor, to now give what we call discovery to Ms. Gordon. That's the police reports and anything else the state has. Ms. Gordon's going to come see you with all those papers to talk to you about what's in the case so that you and she can start figuring out, hey, this is a good case for you. The state has no evidence. Let's go to trial. Or, it's not such a good case. Here's surveillance video and you're wearing your T-shirt that says, my name's Antoine Brinkley, and you're on the video camera. And I don't know what happened in this case at all, but Ms. Gordon needs to read all that and talk to you about it so we can figure out what we do next. Does that make sense? Yeah. Okay. She's just not here today because she filled out some of that paperwork. She didn't let us know that she had filled that out. We wouldn't have dragged you all the way over here if we knew that. But I wanted to explain what today was supposed to be. You would have sat next to Ms. Gordon for about 30 seconds. She would have said, waive arraignment. I would have said, great, we will see you next, either because your lawyer files a motion, like a motion to suppress, or you and she have tried to work the case out, and maybe it's a plea, or for trial. Okay? Any questions? All right, hold on one second. Yes, ma'am. Yeah, we'll get you that information. So your mom's here, and we'll make sure that your mom gets Ms. Gordon's information. All right, Mr. Brinkley, we'll see you soon. So Ms. Primovic or Ms. Wood will get you the contact information for Ms. Gordon, okay? And you are welcome to be here every time your son comes to court. It probably won't be for a little while, because the next step is for Ms. Gordon to spend time with your son, going over all this discovery. She'll probably go over it with you as well, so you know what's in the file. All right, Mr. Hiles, that was painless. All right, go indict a case for a different judge.
For you today, Your Honor.
All right, thanks.
The judge can have an excuse as well.
Yes,
Thank you.
you bet. I'm going to bounce around a little bit more because I think we've got Mr. Melnick on for a case that he may be coming off of. And we'll see if that person is here. Is Tuit here?
Yeah.
If we could bring Tuit, and Tuit will need to come all the way out. More.
Morning, Judge.
So, Mr. Jordan, all these pleas you were going to have before we call the trial calendar, that's tomorrow afternoon.
Yes, Judge. I tried my best to move all of them up early, but unfortunately, everyone had a conflict. So
Yeah.
I'll bring my water and make sure that I'm ready to speak a lot.
All right, good. I don't know the thinking behind putting you in trial the week before your own trial calendar, but I'm not a supervisor at the district attorney's office. Ms. Olivier, good morning. Are you here for Tuit? You're allowed to sit up at the table there if you want. You always have to lurk in the background. All right, let's talk a little bit about position 8. Mr. Tuit, I'm Judge McBurney. How are you?
I'm okay, sir.
Mr. Tuit, today is supposed to be your arraignment day, which is the first step before then the state starts giving discovery to your lawyer and we figure out where your case is going. You're charged with murder, so it's a pretty serious charge that is going to move a lot of attention. In the docket is a motion from Mr. Melnick, who you can see on the screen, in which he asked me to remove him as your lawyer. It's a motion to withdraw. And in his motion, he said that you and he have spoken and you've told him you don't want him to represent you anymore. So I brought you out here because we need to get to the bottom of that. I can't move your case forward until you've got a lawyer. And I can appoint one if you are unable to afford a lawyer. If you plan on hiring a lawyer that's not Mr. Melnick, I need to know when you're going to do that. And if you've had a change of heart and you want Mr. Melnick to still be in the mix, you and he and I are going to need to talk about that. So I'm going to start with Mr. Melnick. How did you get involved with Mr. Tuit's case, Mr. Melnick?
Judge, I had represented Mr. Tuit before, and just to kind of cut to the chase, since I filed the motion, I should have notified you, Judge, and I'm sorry that I didn't. Mr. Tuit's reached out to me. His family's reached out to me. They've asked me to remain on his case. So unless Mr. Tuit has something else to say besides that, I believe Mr. Tuit wants me to remain on his case.
What's the good word, Mr. Tuit?
Yes, sir, I do want him to remain on the case.
Okay.
Yes.
So Mr. Melnick, is Mr. Tewitt waiving arraignment?
Yes, Judge, we'll waive arraignment, plead not guilty. And I'll file all my necessary motions today.
Couple things. The main thing I need you to file today would be a waiver of arraignment. So then that'll trigger the scheduling order that Ms. Nelson will get out. That'll give Ms. Olivier a deadline to get you discovery. And as you know, from practicing in my division for a while now, your substantive motions, a motion to suppress or what you might find after you look over the discovery, that won't be due for a while. So there's no need to file a boilerplate, suppress my client's statements until you know, did Mr. Tewitt even give a statement? And do you want to suppress that statement? The main thing will be get that waiver. Will prompt the scheduling order, and then we'll be able to move Mr. Tewitt's case along. Mr. Tewitt, Mr. Melnick will be in touch with you once he gets that discovery. He's going to want you to look at it as well. He's going to want to tell you his perspective on how the case looks. Is it strong for the state? Is it weak for the state? And then you and he will talk about next steps. Maybe he's going to file some motions. It may be that you and he want to talk with the state about working the case out. And it may be you're just ready for a trial. Mr. Melnick will be there for you for any one of those three outcomes. I will see you next either because Mr. Melnick has filed a motion where we need a hearing, or for what we call a status conference, which is when I get confirmation that Mr. Melnick really does have all the discovery, there's nothing missing. And that's the last chance for there to be a negotiated plea where you could withdraw your plea if you don't like the sentence I give you. After that date, you can always work the case out, but you're stuck with whatever sentence I give you. Given these charges, it may be more likely that it's a trial than a plea, but things happen. And we'll see what you and Mr. Melnick decide. Do you have any questions about any of that?
I do have a question. Like 2 weeks ago, I was just stabbed multiple times inside the Fulton County Jail. I was just stabbed like 21 times.
Okay.
And I'm just gonna cut the chase here. Like I really fear for my life in the facility. Like I almost died. They punctured my kidneys and bust two of my main arteries. And I'm just trying to see, is there any kind of way that I can get emergency bond or anything to try to, because I fear for my life inside the jail. Like it's not safe.
It doesn't sound like it if you got stabbed one time and you got stabbed 21 or 22 times.
It's by like 20 inmates.
Okay.
And you know, it was like, I secured my door and they still popped my door themselves and came in and I almost died. I passed out and I bled out a lot. And
okay. Well, I'm glad to hear that you've recovered some, not ever fully recover for something like that, but I'll note for the record, you walked in here on your own, which is impressive.
Yes.
Mr. Melnick, what I'll ask you to do is confer with Mr. Tewitt, and at a minimum, if I need to intervene in some way in terms of relocating Mr. Tewitt, there are other options besides Rice Street. And I think if you got a hold of an incident report that highlighted even half of what Mr. Tewitt just described, that would be a sufficient basis to get Mr. Tewitt into a different location. And it may be that what you and he decide is that a bond motion is the way to go. And certainly you can file that and we'll hear it. Nothing we can do today because the state notice of a bond motion. So if they want to bring any witnesses, they can do that. And it wouldn't be witnesses about the jail situation. It would be witnesses or family members of Mr. Wright, who's the person you allegedly killed. And that family always needs to have notice statutorily. They have a right to notice of anything like a bond hearing. So Mr. Melnick will be your point person on that. I'm just sharing with you, there's an option short of emergency bond because those are rare, although your situation is pretty extreme. And that would be, hey, let's get Mr. Tewitt somewhere else. So talk with Mr. Melnick. He'll be in touch with you. And that would be the kind of thing we do real soon. If he files a motion to suppress, it's going to take a while before we hear that. But anything along the lines of emergency motion, we bump that to the front of the line. Okay?
okay.
All right.
Judge, I know for a fact that this is what happened to Mr. Tewitt. Is there anything we can do about the situation today? Mr. Tewitt, I mean, how would you feel about being transferred? Fulton County is housing inmates in Cobb County right now. How you would feel about that?
And I don't feel like there's any difference with moving because this stabbing is going on in Cobb, Clayton County, and all the metro Atlanta jails. You know, I've been to Cobb before, so I pretty much know how it works out there too.
Well,
It's
Mr.
like-
Mel, given that response, why don't you talk to Mr. Tewitt where you and he can speak privately?
That's what I'll do, Judge. Mr. Tewitt, I'll come out to the jail to see you tomorrow.
And he may decide that the lesser of two evils is Cobb, and then we'll see what we can do about that. But I appreciate that may not be a huge difference. It may be not as bad. And we'll see what we can do. All right. Anything else, Mr. Melnick, on behalf of Mr. Tewitt?
Not at this time, Judge.
Ms. Olivier, anything on behalf of the state?
Nothing else, Judge, no.
You'll get discovery to Mr. Melnick.
As soon as he files for it, yes, sir.
Okay, so I guess those are the things you do need to file, that you're engaging in typical discovery, et cetera, Mr. Melnick. And if you don't mind just adding to your workload, if you would file something that withdraws your motion to withdraw, then that'll clear up the docket so that I don't forget and 6 months later say, wait a minute, we have to find a lawyer for Mr. Tewitt, because he's found one and he's good to go.
I will do that, Judge. Thank you.
Okay, thank you.
And Judge, that's all my business. May I be excused?
Yes, ma'am.
Thank you.
Deputy Gordon, have the female inmates made it over here?
Yes, I have to go down to jail.
Okay.
And, one and two, he's downstairs.
Okay, he does not need to come up. That's Mr. Davis.
Yes.
Yeah, he doesn't need to come up unless he's saying I need to talk to someone, because Ms. Feely took care of everything for him, other than telling Ms. Nelson he shouldn't be brought over.
Okay.
All right. So Stanley Adams is next. Ms. Wood, is that your client?
He is, Judge. If we can hold, there's a chance we might be putting this up non-negotiated today.
Good. That's what I wrote next to it, is resolve. Just looking at the second case makes it a little more complicated, but the first one. All right. So we're not going to bring Mr. Adams out quite yet. Brian Arnold, that's Ms. Feely's case and she's waived. Is he up?
Yes.
Okay. You can just bring him right to the door. Is this your case? This is a weird case.
It is, Judge. Positions 9 and 10 are mine.
Right.
And I wasn't aware Ms. Feely had position 9, so I have discovery ready.
Okay. And is Attorney Smith on the, I don't know this lawyer. Nope. All right. Hey, Mr. Arnold. I'm Judge McBurney. How are you? Good. Your lawyer is Ms. Feely. I don't know if you've met Ms. Feely yet.
Yes, sir. She came over to the jail once.
Good. Well, she's going to keep visiting you. She's not here today because she filled out the paperwork she needed to take care of today. Today is your arraignment, where I introduce myself to you. I meet you. And in theory, if Ms. Feely hadn't waived your arraignment, I would read into the record the indictment and tell you what the maximum penalty was for each count. But Ms. Feely has said, I understand it. My client enters a plea of not guilty. And then she's asked the state to please provide all the discovery in the case. I know this is an older case and you've been in jail for a while. So I am anxious to keep it moving along. Ms. Feely understands that. She will come see you soon with the discovery so that you and she can go over it together to figure out, what are we going to do next? Are we going to file some motions? Do we want to work this case out? I was just telling the prosecutor, the gentleman at the table further from you, it's a peculiar set of facts where there is a dead body, but you're not charged with murder. There's a dead body in his own car, and you're charged with things in connection with maybe what got taken from that car. So it's a different set of facts. But Ms. Feely will work with you on that. I know you've got a co-defendant, but that's her business, not yours. And Ms. Feely is going to be focused on resolving your case. Do you have any questions about any of that? Okay, so Ms. Feely will see you soon after she's received discovery, and she'll help you figure out where you're going next.
All right.
All right, nice meeting you.
All right. Thank you, sir. Thank you. All right.
All right, we cannot do Ms. Craig yet because she's downstairs. Ms. Smith filed an entry of appearance. She is with the alternate defender's office. She filed it in this case when it was assigned here. So she's a colleague of Eric Johnson's. Obviously, he can't be picking up cases right now. I've never met Ms. Smith, and I'll note that she's not here. So we'll do some outreach. I wasn't sure if either of you had interacted with her. Nope. Okay. We dealt with Mr. Brinkley, Mr. Carbo, another waiver. Is Mr. Carbo up?
Yes.
He is? Okay, we'll have the same conversation.
We'll leave. Be good.
Oh, we don't need to talk to him? Okay, okay, all right. Thanks, boss. If you say so.
Your Honor, if I may, on that particular case, Attorney Feely and I had been discussing a negotiated resolution. I had to reach out to the officer that was the victim in the case, and so I couldn't give the okay to Ms. Feely's proposed resolution at the time. But the officer did reach back out to me, and he said he was fine with the proposed resolution. So that might be a case that we can handle today if Ms. Wood or Ms. Primovic would be ready to handle it.
So let's leave Mr. Carbo up, and much like Mr. Adams, maybe that's one we can sort through today. We've got time. So let's see if one of you would chat with him, as long as you know whatever the deal is. Okay, so we'll hold Mr. Carbo up. Azaria Dyson, that's a female. She is, so she'll be brought up. And that's it for this calendar, but we also had a status conference calendar. Do you guys want to do that first before they do the swapping out? Okay. Were people supposed to be showing up for that, or how are we? Maybe we want to wait because it's not 10 yet. I'm noticing no one in the courtroom and a bunch of bonds.
There was a notification calendar.
I had asked for Mr. Moore and Mr. Ross to be able to log in via Zoom.
Okay.
So I'm not sure if they're on there.
Well, they're not late yet. So why don't we do this instead? I'm just seeing if there was anything else we could take care of. What are we doing with Mr. Lloyd?
Mr. Malik will be signing back on.
He's still here.
I'm here, Judge. I'm sorry. So Judge, I know it's on for status. We had done a bond motion. I think we did it initially in August of last year. There was a follow-up in October of last year where the state had submitted some jail calls that they thought were pertinent to the issue of bond. And then, so we had agreed that you could just, rather than try to sort through all that in court, which could take a long time and is very tedious, that the state would submit the jail calls to you, you'd listen to them, and then make a determination as to bond.
Right. And my determination was that Mr. Lloyd ought to stay where he is until his cases are resolved. So,
I don't think he had attorney on that second case. Now he has some.
okay, I guess the other piece was that Mr. Lloyd has a second case. You, Mr. Melnick, represent him on a case in which he's charged with assault. There's a second case where he's charged with kidnapping and more aggravated assault. And that was, I now have down that Ms. Feely has that case. And I guess, Mr. Whitenauer, you are the prosecutor for both.
No, Judge. I'm handling indictment ending 917. That's at position 6 on the second calendar today. And it's the state's announcement today that we'll move from null pros on that case. The victim is deceased for unrelated reasons. She died of a drug overdose in New Jersey. We confirmed that by death certificate. We had explored possibly prosecuting this case without her, but it does not appear that the evidence that we have would be sufficient to do so.
So you've moved to null process. Ms. Nelson and I will take care of that. That will come off the docket. And then that leaves, it's just Mr. Jordan's case with Mr. Melnick. I think it's high time we get it on a trial calendar. Mr. Melnick, then we can't expedite it to a trial calendar?
No, we can go ahead and put it on a trial calendar, Judge.
Okay. We'll do. Any is he up? We can briefly talk to him about that. Okay. If you could get Mr. Lloyd in a moment.
Judge, I'm having an issue with your microphone this morning. So I don't know if there was a question there that I needed to answer or not. I'm not actually catching every word that you're saying right now.
I appreciate you flagging that. Can you hear me right now?
Yes, I can hear you right now.
Someone else said that the mic wasn't working well. I don't know what that's about, but I apologize that we're having a technical issue. No, I didn't have another question. Can we bring Mr. Lloyd out, please? You're Ms. Benton? Great. Is Ms. Rockwell going to be dialing in or showing up? Do you know? She's coming she's coming virtually, I just heard. Are you Mr. Lloyd?
Yes, sir.
How are you, sir?
I'm all right. How about yourself?
Good to see you.
Good to see you too.
So, Mr. Lloyd, I've got two announcements for you. One is just an update, and the other is good news for you, I guess. You have two cases. One, the state has just dismissed. There are allegations that you committed an assault on a woman and kidnapped her. She's deceased now. She died up in New Jersey, and the state has decided that they cannot go forward with that case, lacking the alleged victim. So you're down to one case, I think. That's the one where Mr. Melnick represents you, and you can see him on the screen right there. He's told me he's ready to go. So we're going to move that case to a trial calendar. That doesn't mean they'll have a trial. It could be a trial, but the prosecutor, who's sitting over there, and Mr. Melnick will talk about resolving it. And if it's not something that's resolvable because the state's offering too much and you don't think, or Mr. Melnick doesn't think that makes sense, then we'll get you a trial. One way or the other, we need to get closure. One case missed, but this other case is still out there. I'm going to make sure it gets on a trial calendar real soon. Okay?
Okay.
Any questions about any of that?
No, sir.
All right. Good seeing you.
Good seeing you too. Oh, that's it.
That's it.
Oh,
I just wanted to give you that update.
Oh, sorry. It's one question. Is it a way that I can get a bond for the case? My new case?
So Mr. Melnick asked about that because he had filed a motion, and I told him I wasn't sure what we were going to do with you today, that for now I've said no bond. I think this is more important for us to sort this case out one way or the other. But I'll tell you, if this case gets delayed, then Mr. Melnick should then file another motion for bond. But I've denied his motion for bond so far, and it doesn't make sense to file a new one. Changed. And what would change would be if the state says, well, we're not ready. We can't find a witness or something that's not your problem. Then I need to think differently if I have a bond or not. Okay. All right. Mr. Melnick, you'll be in touch with Mr. Lloyd, and we'll get this on our next available trial calendar.
Thank you, Judge.
Thank you.
Mr. Jordan, if you have any time, you want to give me a call, we can talk about this case.
Yes, sir.
All right.
So Baxter Ross is on. Why don't we handle that status conference? It's 2 cases. But we need Baxter Ross to turn video on.
Hello? Hello? Hello?
Mr. Ross, I think you just want to wait for a minute.
It's a nice looking car. All right. Hope you weren't driving. Your seatbelt's not on either. All right, let's ask him to unmute.
Sorry. Hello?
Kiki on over.
Hello? Mr. Ross, I think the judge is doing something, but I can hear you okay.
Hear any of this?
with the prosecutor, and I don't want the court to think that I don't appreciate his Zoom, but since I was here anyway, I wanted her to come because it's hard to share the evidence.
No, I think it's great that you're here, especially since right now is not working and people who are not in court can't hear those of us who are in court.
Just a thought, if y'all want to put just a note to them in the chat, this is what I have to do sometimes.
I did. I've told them is broke.
For them to call in, and then they can be on their phone and on the device.
Oh.
Two devices.
You can hear again? We still need IT. I don't understand why it's going on and off, but okay. You can hear again. Great. So you want to talk with Mr. Jordan? We can do that. I guess you can see what else is going on. Mr. Whitenauer is coming this way. I guess you, Ms. Wood, can figure out where Mr. Moore is.
Yes, Judge.
And I don't know about Ms. Tinch. That would be a Primovic matter for purposes of today. And why don't I take a break? That way you guys can take people down, bring people up. Please leave up. Where did that calendar go? Mr. Adams and Mr. Carbo, Mr. Green. I think that everyone else can go down and then the females can come up and I'll come back out.
Judge, I do have one question.
Yes, ma'am.
Can you remind me of what your rule is once we move off the final plea?
Yeah, so status is the same as final plea. We just call it status. So today is the day for Ms. Benton, if she wants to enter a plea where she could withdraw it, if she doesn't like the outcome, that's today. After today, Ms. Benton is free to enter a plea and it can be negotiated. It's just not something that she could withdraw if she didn't like the sentence that she got.
Understand. And I'm conferencing right now with the state, and it does look like she does have an open, unindicted case. And just in the sense of judicial economy, Mr. Jordan has his eyes on everything. And would that be a big imposition to the court if we just get one more very short final plea to see if we can do a global resolution on that?
What is the
Mr.
case number?
Your Honor, it is 21 CP 204237. And it's an aggravated assault family violence, Your Honor.
Don't you think that would be a better move?
Yeah, I think so too.
Oh, Ms. Rockwell, you have that one already. You represent her on that too. Okay, and it's a different case. Okay. Why don't you guys talk and let me know what your plan is. I'll come back in a few minutes. Sorry about that, Mr. Whitenauer. I don't know what the technical issue is. And we'll see what we can move forward. So you'll let me know when the inmates are swapped around, or Deputy Gordon will? Okay, thank you.
Did they say if the probation?
What is this?
I know it was brought over. I don't know if he's up. I've written down his allegations.
You got you something that was good. Before the beginning of the year. No, okay, no, it is hard. What's up?
Let me ask you this, I am Judge Carter, making announcements like for 3 other lawyers. I don't know, everybody knows I'm here today. Do you mind if I run and do that, and then we'll ask DJ one another final plea? Yeah, red card tomorrow. Can you do that via Zoom?
It's a calendar call to get the in-person.
I'll say, okay, so it's in the afternoon, correct? Okay, that's fine. I didn't know because
I know.
I'm not keeping up.
You're everywhere.
It's too much. Y'all having trouble keeping up?
Every day.
Why are you like calling in for probation?
Because they're shooting folks out.
Yeah, you're right about that.
You saw that?
Good point. Valid.
No,
You know, they don't shoot people here.
You were? Oh my goodness, it's a lot of fun.
I'm playing these people.
It's got a little too dangerous. Okay, I'll be right back. Let me go and do that. And then we'll ask Deidre what a short said.
Okay.
I'm not trying to put any work on John, but does it make sense to try to?
We can find that.
I'm just find out that I'll let you. Do you mind calling me?
Sure, actually, we're from.
Okay.
So that's the only case he has. Yeah.
So I already have the extra What number is
That's the
that?
only.
That's all this and that's stuff.
Is that personal?
No, that's.
Okay. I'll just, okay. Your phone's dead, but anyway, okay, you got me.
I got
You can fix it, come back for a second.
Okay.
And listen.
Okay.
You don't use. You can do it here.
So the case.
Okay, I just see
And so what did you? So our message, so I think that we need to do probably this feeling of selling. That issue. Since you actually I'm fine to give that, I would just do something.
Thank you. Hey, this is interesting. I was doing, I would say.
All right, how are you?
So sorry.
That's totally fine. I wrote down all I need to know to talk to him, so.
So, here we go.
Perfect. I'm gonna try to call this more really quick.
See, I understood there was this agreement.
Yes, one of us is gonna pop back there. Do you have a recommendation?
I just think, I think it's almost close to 4 months, so my recommendation would be 4 months.
Perfect. Okay. One of us will pop back there.
Okay.
Thank you. Which person are you doing? Oh, you don't have to unless it's, what's the charge? No. You don't have to do that.
Ignorance.
Yeah, no, totally. Just. Yes.
All right, very well. So I'm gonna come back and work. Good level headed. Yeah.
She's teacher's pet.
That's the job is.
Mhm.
So many times you call me after
I can see that.
I had a feeling of the case. But
It's fantastic.
Make or break the case. That's the result. Yeah. Basically, I'm surprised. Exposing. Yeah.
You need to speak with a couple people.
Compliments or what? Is Mr. Carbo up?
Yeah, Carlos. Next. Excited. She got new tricks up this week. Yes, I'm excited. So, what you do, right? You know, you do what I It's based around, like the story that was based around football.
Yeah, even, you know, stuff, but like, redoing it is like, you really need to. What do you want me to find? So definitely. These were in the yes. Yeah. Just know that's right satisfaction. It's just it's a hard thing. That's what you're asking when you know.
Let's see if the All right, Mr. Moore, can you hear us?
Yes.
Ooh, all right. How about Mr. Ross? Are you able to hear us? We'll see. He's probably driving with no seatbelt right now. Well, Mr. Moore, let's work on your case. Mr. Jordan, did Ms. Rockwell and Ms. Benton, they're just outside? They haven't left for the day?
Your Honor, Ms. Rockwell had another matter in another courtroom. I just texted that.
I'm here, Your Honor.
Oh, look at that. We got Mr. Ross too. All right. He's got a seatbelt on. All right. Stop driving, Mr. Ross. We're going to get to your case in just a minute. We'll start with Mr. Moore. Mr. Moore, can you hear me?
Yes. Yes, sir.
Great. We seem to have fixed our audio situation without the aid of our IT team. There he is. And Ms. Wood, this is your case. Let me add you. Got everyone we need? Okay. Mr. Moore, this is your status conference. This is when I learn whether your lawyer has all the discovery, if we're working this case out, or if it's going to trial. So, Ms. Wood, I'll start with you. How is discovery looking?
Thank you, Judge. So there was a hiccup. There was a certificate of discovery filed by Mr. Hand back in November. I believe that was the week before I started the Landon Christopher trial. So I missed double checking on that. That discovery actually went to one of our state court attorneys, but Mr. Jordan has rectified the issue. I have everything now. I ended up filing an untimely motion to suppress on Friday. So I would like for this to go to a motions calendar with the caveat that Mr. Jordan and I are going to talk about this case to see if there's a resolution.
Okay. Mr. Moore, were you able to hear Ms. Wood while she was saying all that?
Yes.
Good. So through no fault of your lawyer, discovery didn't quite get to her. I don't know. Is there another Wood or Kyle's in your office? Why?
There's a Woods, but I don't think it went to like Javier Trejo. So I don't know what, it was a total misfire.
Okay. So yes, very just like that. You guys maybe have offices next to each other? No, not even that. I was just hoping. Anyway, Mr. Moore, the discovery took a little while to get to your lawyer. She's gonna, well, she's already looked at it. Apparently she's filed a motion to suppress. Usually in cases with charges like yours, there was a search and something was seized. And she, Ms. Wood, wants to challenge that. So we'll get you in court. Some police officer or officers will need to come in to testify, and we'll have that hearing. It may be before then that you and Ms. Wood reach some kind of agreement with Mr. Jordan, the prosecutor, and then we'll handle it that way. But I see two stops for you. Next is the hearing on the motion to suppress. I'll rule on that. If it doesn't go well for you, then we go to trial. If it does go well for you, usually the state has to dismiss the case. Does that make sense?
Yes.
Okay. Do you have good phone information for Ms. Wood?
Yes.
All right, Ms. Wood, you've got good contact information for Mr. Moore?
I do, Judge.
Excellent. So Mr. Moore, be on the lookout for another court date for this motion to suppress, okay?
All right.
Ms. Wood, anything else on behalf of Mr. Moore?
No, Your Honor.
Mr. Jordan?
No, Your Honor.
All right, we'll set this down for a hearing on the motion to suppress and take it from there. You're free to go, Mr. Moore.
All right. Thank you. Y'all have a good one.
You too. All right, let's get Mr. Ross front and center now that everything is working. There he is, seatbelt on, not driving. Mr. Ross, you've got two cases on our status conference. One, Ms. Wood represents you on both, but two different prosecutors because you got allegedly mixed up in two different types of crimes. Not quite sure how you managed to get bond on both, but I guess that's just how it played out. Ms. Wood, do you have discovery in both cases?
Judge, I just got the file late last week from, this second case was assigned to Judge Cox. And so one of our attorneys in there had been working on the case, but I did get the file from her. So I think I do have everything.
When you say the second case, the one inning in Mr. Whitenauer's case just bounced from Judge Cox. That's the higher number one?
Is that the 184531?
Yes.
Yes.
Okay. So your case, but new to you in the sense that your colleague in front of Judge Cox had been handling that.
Yes.
Got it. Okay.
But I think we're good to go forward to a trial calendar.
Okay. Mr. Whitenauer, what do you want to add?
Judge, I just wanted to let the court know, and Ms. Wood, that I'm handling both position 2, ending 543, and the add-on ending 531. Both of those involve the same victim, India Foster. He did have a third case against that same victim. He entered a plea on that, and it was released after time served. So state discovery has been served on both of those cases, Judge. November of last year. State's ready. The only thing that we would need to address before trial would be the subsequent difficulties, as indicated by that plea 121 SC.
The subsequent what?
Difficulties. So he entered a plea with the same victim, India Foster, on 21 SC 179-977. He was in Cook County Jail for 376 days, and he entered a plea to year to serve.
Got it. Okay. Was that here or yet another judge?
Judge Cox, it looks like. I just pulled it up.
Okay. So we somehow got in between the Cox sandwich. I mean, he had the old one, he has the newest one, and we had this middle one. And so we now have everything. Okay. All right. Well, here we are. So Ms. Wood, the older of the two cases, the one ending in 543, you've got discovery for that.
Yes. Judge.
Okay. So move these to a trial calendar.
Yes, please.
All right. Mr. Ross, we've been talking a lot about you. Have you followed it? You have any questions?
No, sir.
So you've got two cases with me now. Both involve this same young lady. I'm assuming you are having no contact with her?
No, sir.
Yes, you are having contact with her? Or no,
I said no, sir.
Okay.
No, Your Honor.
Okay, it's sir's fine. All right. Ms. Wood, anything else we need to cover?
No, Your Honor.
Mr. Ross, you have good contact information for Ms. Wood, your lawyer?
I'm not sure. Is there a way I can give her my number? So I just got a new number.
Yeah, I bet she'd love your number. Why don't you tell us what it is?
Can you give me a second? It's 2 seconds.
Sure.
470-816-8054.
Got it.
All right, Ms. Wood will add that to her file so she can keep you posted. Did you get something in the mail telling you to plug in today?
All my mail goes to my grandmother's house, and she gave it to me like 2 days ago.
Well, should we have them?
I got an email, Your Honor, about this.
You got an email? Okay. From your lawyer?
Yes, sir.
Okay. Should we be mailing things to a different place, or does it make sense to mail to your grandma?
No, it's good. I just gotta go pick up my mail and things like that. But
Yeah, that's a good idea, because if we mail it to the address you've given us and you miss court, you don't get to come in here and say, "Ah, my grandma's a bum." It's on you and not your grandma, okay?
yes, Your Honor.
All right. So the next notice you're going to get, Mr. Ross, will be for trial. It may be that you and Ms. Wood and the prosecutor work something out before then, and then she'll help schedule a date. But otherwise, the next thing we're going to mail you is a notice for you to come on in for trial.
Okay.
All right. Mr. Whitenauer, anything else for the state? Okay. Mr. Ross, thanks for your patience. You're free to go.
All right, thank you.
You bet. So Ms. Rockwell disappeared again. When she comes back, we can do Ms. Benton. How about Ms.
Hola. Hey, Judge.
Oh, well, that was magical. Hey, Ms. Benton, stay here. She's on the call. All right, so what are we doing with Ms. Benton? I know there's this wrinkle of an old 21 CP case. What did you and Mr. Jordan or Mr. Whitenauer or whoever it is figure out?
Judge, would that be asking for too much if we could get one more final plea? Mr. Whitenauer has the CP number for the 21 case, and I trust that he could probably have it indicted in short order. And it does look like it is a DV case. The victim, I think the state's going to see, is someone that she has a child with.
The case that is indicted, is that a DV case as well or not?
No, Your Honor, it's my case.
Okay. We might be able to have things travel faster if there were a waiver of indictment executed by Ms. Benton. But I'm going to let you and Mr. Whitenauer work through that. I will reset this once. And what I'm resetting is the indicted case, the one ending in 599. If Ms. Rockwell, you and Mr. Whitenauer can either agree that it can be an accusation, or Mr. Whitenauer is able to move it fast enough that he can get it indicted, then we'll have two cases. But I'm not going to hold up the case ending in 599 for a CP case that is going to be a couple years old sometime soon. So we'll see how that plays out, but we'll do one reset for one more final plea.
I understand. Do you have, Judge, does Mr. Whitenauer think that he can go ahead and accuse this with that waiver if I provide it?
I can accuse the case if you can complete that waiver of indictment and email it to me.
Wonderful. Okay, Judge, she's in the courthouse today. I know time is of the essence. Does anybody have one of those blanks, or I could search in my bag of tricks and see if I can find one, but I'd love for her to sign it today. We can get that to Mr. Whitenauer immediately.
Okay, I don't know. Ms. Wood is looking, but I don't happen to have one, so we'll see.
I'll figure it out, Judge. It doesn't have too much magical information or language, or we can figure it out. Thank you, Judge.
What should we tell Ms. Benton? She's sitting here patiently. Should she wait for you to come back in here?
Yes, tell her to come to 5F, please.
Oh, 5F as in Frank?
Yes, Judge Carnicel, 5F.
Okay, all right,
Thank
we'll do
you
that.
so much.
All right.
Debbie,
Yes.
thank you so much.
So Ms. Benton, 5F as in Frank. So 3 floors down, all the way to the end is where you'll find Ms. Rockwell. I think she's going to want to talk to you about signing some form so that this older case can catch up with the one that's on this calendar. Any questions?
Yeah, he just went to court for that same case too. So I think he's on the same thing, getting a waiver.
He, meaning the father of your child? Okay. So you both were charged with it?
I was charged with aggravated assault because I had to, he was charged with battery because I had my neck.
Okay. So whatever happened, the police charged both of you?
Yeah, they said they was only taking him him, but I guess now the law, we gotta take both parties.
Who knows? But there is this charge hanging out there. Mr. Whitenauer, the gentleman with more hair sitting in front of you, he's the one who'll be handling that for the DA's office. So he'll work with Ms. Rockwell on that. But you should let her know that the father of your child got charged in that as well. That's often something you did, but that's often defense attorneys like to say, look, this was clearly not one person stalking another, but they were having a fight, whatever the deal was.
Okay, and another thing, that was my first time getting arrested, so how long does it take after that case over with to get it expunged?
So it's a great question for Ms. Rockwell. Usually you cannot get anything expunged until your sentence is complete. So something's going to happen with both these cases, the indicted one with Mr. Jordan and the unindicted one, but may soon be indicted with Mr. Whitenauer. So I'm going to make it up. Let's say your sentence is 2 years probation. You can't have anything expunged till you finish your sentence. Okay? You bet. How many courtrooms do you cover, Mr. Whitenauer?
3,
Who are the other 2 judges?
Whitaker and Dunaway.
All right. Ms. Tinch is position 4. She's our last status conference. That was a Ms. Feely case. I don't see Ms. Tinch online. Any notes?
She emailed her, Your Honor, and the cell phone was out of service.
All right. Mr. Whitenauer?
Your Honor, if this is a notice calendar, the state would move for bench warrant bond forfeiture.
It is, and we'll do that. If you can make sure that your office takes care of its part of the paperwork, Ms. Nelson will take it from there.
Understood.
All right,
If you
then,
go to a trial calendar, Judge, we have all the discovery whenever that happens.
okay. Let's go back to our first calendar. And we need to work through, I don't know if you had a chance, Ms. Wood, to speak with anyone. I stayed away for extra time. We've got to deal with Mr. Green, maybe Mr. Adams. And we have now, our females are up. So we've got Ms. Dyson and then maybe Mr. Carbo.
Judge, if we could start with Mr. Green.
Sure.
That will be relatively quick.
Great. All right, Ms. Toussaint, we're going to do our probation revocation.
Your Honor, that concludes my business if I may.
Okay, gotcha.
Yes, sir. Thank you.
Talk to you later about James Christopher.
All right, let's go on the record with position 4. It's 17 SC 155858. We've got Mr. Green. Hello, Mr. Green.
Good morning, Your Honor.
Good morning. We have Mr. Jordan here for the state. Ms. Wood is going to handle things for Mr. Green. Mr. Green, you were put on probation as part of this case. And in September of last year, I signed a warrant that alleged that while on probation, you committed new crimes. Specifically, in August of last year in Douglas County, you were arrested for driving with a suspended or revoked license. And then a couple days later, arrested for criminal trespass in DeKalb County, although that arrest was for something that happened back in May of 2022. So we've got a driving with no license or suspended license and a criminal trespass, Douglas and DeKalb County. Ms. Wood, well, let me ask Ms. Toussaint first. How much time remains on Mr. Green's case?
On Mr. Green's case, for this particular case, he has 1 year, 9 months, and 9 days remaining. And then there's another, it's a Carroll County case he's on probation for.
Okay, out of Carroll County.
Yes, there's a Carroll County case. He'll be on probation for quite a time.
Okay, got it. But we can only work on this one right here.
Right.
All right. So Ms. Wood, what is Mr. Green? Is he admitting to these arrests, or does he want an evidentiary hearing? What's his plan?
We're admitting to the arrest, Judge.
Do you know if any of them have been resolved?
I believe he's out on bond for both of them. I do know that he sat for an amount of time in both counties
Okay.
before coming here.
And do we know if there are any holds on Mr. Green?
There are, Judge. There's a Carroll County hold. I believe it's fleeing and eluding is the underlying probation. So he does have some exposure he's facing in Carroll County.
Okay. And then he's got these unresolved matters, misdemeanors in Douglas and DeKalb.
Yes, Judge.
All right. So what is your recommendation, given Mr. Green's admission that he was arrested for these things?
We will ask the court to revoke 80 days. He's been in 79 days at this point, and reinstate. Judge, he's 29. He is a Carroll County resident. He has some college education. He's got one 13-year-old daughter. He is an entrepreneur. He's working on some property and music ventures. And so he's eager to get done with this and go on to Carroll and handle his business there. So we would ask to revoke 80 days and reinstate.
All right. Mr. Jordan, your thoughts about Mr. Green's case?
Your Honor, given that he has spent, I didn't see any previous probation revocations in this particular case, and these are two misdemeanors which are before you today. The state has no objection to the defense's recommendation of revoking 80 days and continuing on probation, especially given that he has a hold out in another county, therefore allowing him to be able to go to that county and handle business out there.
Okay. Mr. Green, how much time did you spend in prison on this case? I see that you pled in front of Judge Downs in May of 2018, so almost 5 years ago, but you got 7 to do 2.
Yes, Your Honor. I was in Department of Corrections for about 26 months or so, but then I had to, the case that I got here in 17, it violated the same Carroll County probation that we're referencing. And so I spent another almost 2 years in Carroll County. So a grand total of about 4 years.
Okay.
Yeah, as a result of this matter.
What's the Carroll County case? That's a lot of probation.
Yes, Your Honor. It's fleeing to elude in addition to aggravated assault.
Okay. So the ag assault would be, he's fleeing and eluding. You couldn't be on probation for all that long, but there was something else. That would be the ag assault.
Yes, Your Honor.
Okay. All right. So it looks like in the case with Judge Downs, you shot someone.
Yes, Your Honor.
Okay. But you did a little over 2 years. It was 2.5 was your sentence plus a bunch of probation. And then you stayed in longer because Carroll County got a hold of you.
Yes, Your Honor.
And they're going to get a hold of you again.
Yes, Your Honor.
Okay. Being an entrepreneur, I guess, could be a great thing and kind of exciting. You keep holding yourself back with these little arrests. And I don't know what the criminal trespass was about, but driving with a suspended license. I mean, these are setbacks you can avoid, and they're going to interfere with the way you're trying to move forward. What I'm going to do, Mr. Green, I do find that you violated your probation by getting arrested on those 2 different incidents in August of last year. I'm going to revoke 3 months, so 90 days. You'll get credit for the time you've been in. You'll do a little bit more time, although the sheriff may just get you transferred to Carroll County right away. I won't prevent that. And then Carroll County is going to figure out what comes next. I will reinstate your probation. And let me see if there were any conditions. You were supposed to do RSAT while you were in prison. Did that happen? Is drug treatment?
I think I was paroled out before I could do it, but I did undergo some rehabilitation in prison.
Okay. Was there a drug issue you were struggling with at the time of this shooting case?
At the time, yes, Your Honor.
Okay. You feel like right now that's not something you're struggling with?
Not at all.
Okay. All right. Anything else? So I'm not going to change any of the conditions of probation. Anything else, Mr. Jordan?
No, Your Honor.
Ms. Wood?
No, Your Honor, thank you.
All right. Ms. Tucson, do you need any information from Mr. Green?
Not at the moment. If is he going to be returning to Carroll County? I just needed to verify the arrest date, the credit from type serve date. Is it December?
I have December 5th, 2022.
December 5, 2022.
Your
Okay,
Honor.
and do you know if the information we have in the system is correct for you, Mr. Green?
Are you still at Weber Circle?
I'm sorry, what was the question?
We need to, yeah, what's a good address for you?
9041 Tarnwood Circle. That's TARNWOOD Circle, Villa Rica, Georgia, 30180.
Say the zip again.
30180.
And is that in Carroll County?
It is.
Okay. Did you get that, officer?
9041 Tarnwood, TARNWOOD,
Yes, ma'am.
and that's Villa Rica 30180.
Yes, ma'am.
Okay, in Carroll County. I'll be sure to forward this over to your officer.
Thank you.
All right. That's it. Good luck, Mr. Green. I don't know what Carroll County's going to do, but once you tackle that, you can be on your way.
Thank you, Your Honor.
Okay, I'll reach out.
Thank you so much.
You're welcome. Good luck to you. I know.
Ms. Wood, what do you want to do next? Adams or Carbo?
Okay, either Carbo or Adams will be fine.
Let's do Adams, please. Ms. Wood, are we moving forward on both cases or just one?
Both cases, Judge.
Okay.
And if I could just have a moment, Mr. Adams wanted me to show him that these are his only two cases that are
Sure.
still open. So this is the
That's cool.
docket, okay? So all of those are closed. And then you'll see over here in blue.
I'm just making sure.
I know, no, that's totally fair. I absolutely understand. Right here, that's a state court case that we don't have jurisdiction over here, okay?
Okay,
And then that's also a state court matter. And so then these are the only two Superior Court matters you have open in Fulton County,
okay,
okay?
what about the ones that you just showed me, they got bonds on them that you can see?
So I'll show you right here.
Okay.
This is your booking screen with the Fulton County Jail. And so you have bonds on, yes, you have a bond on that one, and the other one you already have on bond. So $2,500. Okay,
That's what it'll be, $2,500 bond?
yes, sir.
That's the only thing I had there.
After you resolve these cases. Yes,
Thank
sir.
you.
Ready, Judge.
Okay. Good morning, Mr. Adams.
Good morning. How you doing, sir?
I'm okay. I'm Judge McBurney. And we're going to see if I will accept your pleas in the two cases I'm aware of that you have in Fulton Superior Court.
Yes, sir.
They both involve theft. Ms. Wood said that we may be doing this in a non-negotiated way. Is that right?
Yes, Judge.
All that means is that it may well be that Ms. Woods and the prosecutor, Mr. Jordan, agree on a bunch of things, but they don't agree ultimately on the recommended sentence. I'll hear from both sides. I may hear from you if there are things you want to add. And then I will, if I'm going to accept your plea, let you know what I think a reasonable sentence is. This is so early in the process that if you don't like the sentence that I propose, you have the ability to say, no, thanks. And we just keep moving your cases forward. There's no penalty. I would never tell the jury, hey, he actually admitted guilt at one point in time. This is a chance to resolve them if you're comfortable with the sentence that you get, but you're not locked in. If I'm making this up, but if I say I'm sentencing you to 5 years to serve, and that's not what you had asked for, you'll have a chance to talk with Ms. Woods and say, no thanks. I would rather pursue, there may be some motions to file, go to trial, who knows what would happen. Does that make sense?
Makes a lot of sense, sir.
Okay. Mr. Jordan's about to put you under oath. Once you're under oath, please answer his questions and mine truthfully and completely. And please continue to do what you just did, which is ask Ms. Wood if you have questions about things.
Yes, sir.
Because I need to be comfortable that you're following what's going on. And one way I know that is when a defendant who doesn't follow what's going on says, wait a minute, what did he mean by that? Okay. All right, Mr. Jordan.
Thank you, Judge. Mr. Adams, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
My name is McCoy Bolton, but they always give me Stanley Adams when I come back.
Can you spell what you say your real name is?
MIQUEL MOTON.
MIQUEL, like Miguel, but with a Q?
Correct.
Bolton?
Moton, MOTON.
MOTON, but you also maybe not voluntarily go by the name Stanley Adams.
That's the name that I served time under, and that's what they gave me when I came back, even though I rightfully gave them my correct name.
Okay, so when we're doing the sentencing here, assuming we go forward with the plea, it will be Mikel Moton, AKA Stanley Adams.
Yes, sir.
You're not saying you are not the Stanley Adams in these two cases. They are you. That's just not your real name.
Correct.
Are you at this time taking or under the influence of alcohol, drugs, or medicine?
No, sir.
Is there any medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone?
46. I went to the 11th, but I received my GED and my barber's license.
Are you able to read, write, and understand the English language?
Yes, sir.
You understand that you have been charged with the following offenses. In 22 SC 184842, you have been charged with the offense of theft by receiving. In 22 SC 184844, you have been charged with theft by taking and indecent exposure.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Lacey Wood, about all of the facts and circumstances known to you regarding the charges in these indictments?
Yes, sir.
Is that also including any potential defenses?
Yes, sir.
Do you need any more time to discuss these cases with you?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Wood, do you waive formal reading of the indictment?
So waived.
Do you also waive any defects in the indictment, including any with respect to Mr. Adams?
So waived for purposes of this hearing.
Mr. Adams, do you recall having been arrested on these two separate charges?
I was arrested on a theft by taking, and a warrant was put on me for another one. I was never arrested for that.
Understood. Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Ms. Wood, do you know of any outstanding warrants that are related to these charges?
I do not.
Mr. Adams, has your attorney advised you the minimum and maximum sentence for each charge which you plead?
Yes, sir.
And just for the record, both the theft by receiving and the theft by taking carry a minimum of 1 year in custody and a maximum of 5 years in custody. The indecent exposure is a misdemeanor, so it is a minimum of 1 day and maximum of 12 months.
Okay.
Do you understand that if you're a guilty plea or a blind plea or also a non-negotiated plea, the state may recommend a sentence to the court?
Yes, sir.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge? Are you aware of the state's most previous offer, which I believe was last week, of 7 years to serve 2?
Yes, sir.
Do you understand that it's, and I apologize, Your Honor, you are allowing him to withdraw the plea?
Yes, sir.
Do you understand, Mr. Adams, that this is a guilty plea which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on the entering of guilty plea today?
Yes, sir.
Do you understand that if your sentence is to include probation of any kind, you cannot violate any criminal laws, any governmental unit, or any special conditions that may be placed on the probation without being subject to revocation for the balance of the sentence?
Understand.
You understand that you are not allowed to possess or use a firearm on probation?
Yes, sir.
You understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
You understand that your guilty plea may affect the following: your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and your right to receive, possess, or transport a firearm, and finally, the ability to obtain employment.
Yes, sir.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
You understand that you waive any and all defenses, including any mental health offenses, by entering the plea of guilty?
Yes, sir.
You understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Adams, how do you plead to the charges of theft by receiving and indictment number 22 SC 184842 and the charges of theft by taking and indecent exposure and 22 SC 184844?
Not guilty.
Did you say not guilty or guilty?
Guilty.
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
You understand that for the felony charges which you're pleading to today, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty.
Yes, sir.
Since there is one misdemeanor charge which you are pleading to, you have 12 months from today to file that same petition.
Yes, sir.
Your Honor, for a factual basis, for the indictment number 22 SC 184842. On August 6th of 2021, an officer from the Atlanta Police Department was dispatched to a motor vehicle theft at 101 Andrew Young Boulevard. Upon arrival, he met with the victim, Ms. Gladys, and that's Gladys Sola, SOLA, who stated that she arrived at the hotel the previous night and gave her vehicle, which was a 2019 gray Dodge Caravan. She gave the keys to that vehicle to the valet driver and went to her room. At approximately 12 midnight, she came downstairs to retrieve an item from her vehicle and did not see any valet worker at the front of the hotel. However, she met a man who identified himself as an employee of the hotel, and they did inform her that they did not have valet access to the hotel. On the same day of August 6th, 2021, an officer was able to track down the stolen Dodge Caravan. They did make contact with Mr. Adams, who was driving the vehicle. Mr. Adams did state that he had purchased the vehicle for $60 from a man that he did not know. The officers then did charge him with theft by receiving stolen property. Your Honor, in regards to that case, the state did not have any request for restitution. I don't believe that there was any damage done to the vehicle. And the fact that the vehicle was found the exact same day, there were no losses to be had. If you'll give me 1 second, Your Honor,
Sure.
I have the report to the other incident.
So I think part of the confusion, the jail still has that as an open case, but it's dismissed. That's dismissed.
That's what I thought. That's what I was talking about.
So I'll send them this order. To records.
If it is missed all the time, I would still be posted.
It's a clerical error, but right here it shows Judge Krause signed off on the dismissal, okay?
And I thought it was dismissed. That's what I was asking. Is there anything else? Anything else? I'm
That's
trying
right.
to be smart enough.
It's okay. I'll send them an email, okay?
Please.
Thank you for the time, Your Honor. On June 5th of 2021.
This is the other case ending in 844?
Yes, Your Honor.
Okay.
On June 5th of 2021, a victim being Mr. Rogers did report that his rental vehicle was stolen from a valet service at 160 Ted Turner Drive, which is the American Hotel. Mr. Rogers stated that he had released his rental vehicle to the valet on June 3rd, and when he returned to retrieve the vehicle, he was told the car had already been picked up. The vehicle was a silver Mitsubishi Mirage valued at approximately $14,000. Officers were able to track the vehicle to 186 Portland Street. Officers did did get a description of the defendant, Mr. Adams, from Mr. Rogers, being a tall black male with glasses, green pants, and a white shirt. Officers were able to review surveillance video from June 3rd from the hotel, and it did show that same individual later to be discovered to be Mr. Adams in the hotel lobby, watching through a plate glass door, and he appeared to be masturbating on the surveillance footage, and that is where the public indecency charge stems from. Mr. Adams was identified because he had been involved in a similar incident. A warrant was then placed for Mr. Adams' arrest.
So With the Mitsubishi Mirage, was Mr. Adams was not a valet worker, but somehow got the keys to the car from the valet setup, but they did have valet at the American Hotel.
Yes, that is correct.
If we fast forward to August, another downtown hotel, that hotel actually didn't have a valet service. And so Mr. Adams was masquerading or someone was masquerading as a valet.
That's what the police report stated, Your Honor. That is what the police report.
Okay. And in the end, Mr. Adams was driving Ms. Sola's minivan, whether he was the fake valet or the fake valet was the guy who allegedly for $60 sold it. Mr. Adams ended up with the minivan.
Yes, sir. That's correct.
Okay. All right. Thank you. And the state's recommendation is 7 years to serve 2 years.
Yes, Your Honor.
Balance on probation. How do we get, if it's 1 to 5? I thought you said.
Yes, Your Honor. That was going to be my breakdown, because I do believe that this would be a situation to where more probation would be appropriate. I believe that we had concerns in that in the second case, which also had the public indecency, that there may be a psychosexual evaluation that's needed. So that's why my breakdown, particularly on 22 SC 184, 842, it was going to be 5 to serve 2 on that particular case. And as to 22 SC 184, 844, for that to be 2 years probation consecutive to 22 SC 184, 842, with the misdemeanor for the 12 months being concurrent with count 1. Just at the state, you may hear from pretrial at someone that Mr. Adams does have prior convictions, that though the theft did not amount to much in both cases, as the cars were returned pretty quickly, I believe that there may have been an issue, and perhaps another issue that's better to talk about outside of the plea litany from a previous court appearance by Mr. Adams, that the state believed that the additional probation will be good to monitor him and make sure he gets some help.
Okay. That makes sense from what you shared with me. Before I hear from Ms. Wood, Mr. York, what can you tell me about Mr. Adams's criminal history? Number of cycles and then anything particularly recent?
So I'm showing 46 cycles, Your Honor, but I'm showing as the most recent felony conviction from 2008. It was a theft by taking. And that's actually cycle 34. So there are other cycles that happen, but they're not showing felony convictions.
Okay. But lots of cycles, but the most recent felony conviction is from about 15 years ago.
Yes, sir.
Okay, got it. Ms. Tucson, is Mr. Adams on probation in Georgia?
No, Judge, not on probation. Last one ended, looks like, in 2021.
Was that the 2008 conviction?
That was from 2007, looks like.
Wow, that was a lot of probation.
Yes, it was 05 SC 30901.
Okay. All right. Thank you. Ms. Wood.
Thank you, Judge. Mr. Adams is 46 years old. He is a resident of the metro area. He has family here. He has a 10th grade education. He has his GED. As he mentioned earlier, he's a barber by trade. I have spoken to his mother, Shirley, a few times. She's eager for him to get out and get back into society and working to help provide for himself and the family. Judge, the reason that we're putting this up non-negotiated today is because Mr. Adams firmly believes that the 564 days that he has served in the Fulton County Jail are more than enough. He feels like that he has been adequately punished and learned his lesson from 564 days in Rice Street. So we are asking for just a straight 2 to serve to be reduced to time served. I have explained to him how the non-negotiated works, that the judge could go with Mr. Jordan's recommendation or the judge could do something different. We would ask you to consider that, and given the fact that he did complete a lengthy probation for an old case, to also take that into consideration.
Okay. Mr. Adams, when you get out, whether it is right away or in a few months, because the two sides aren't all that far apart, you've done about 18 months, you've done about a year and a half, almost 19 months. Where will you stay? Do you have a place to stay?
Yes, sir. 6510 River Park Drive. That's in Riverdale. That's not even in the metro area.
Well, it's not far from the metro area if it's
far
not
from the
in it.
metro area, but I wasn't.
Who lives there?
My mother,
Okay, so you'd stay with your mom.
my mom, and my son. Yes.
Okay, got it. Anything you want to add? I feel like Ms. Wood has helped me understand. I'm sorry to call you Mr. Adams. I should have said Mr. Moten.
It's fine.
Anything you want to add to what Ms. Wood has already described?
Nothing much, just like she said, 500 and some odd days. I'm incarcerated for something that I'm gonna take the plea, but
I'm sure it's more complicated than what we heard about.
Yes, it.
Well, I mean, one of them, you were caught driving the van and it's not your van. So
Correct. I rightfully pulled over and I complied for it because I never felt as if I was in a stolen vehicle. I never portrayed the image of a valet or none of the above. I mean,
well, if you bought
he pretty much summed up everything as far as me sitting here for whatever the reason may be, which we all know now. I have learned my lesson, and I wish you show me a little leniency so I can get
all right.
Your Honor.
Your Honor, if I may, the only condition that stepping up out of their recommendation is that you not return to the American.
Okay. Any reason you'd need to be in downtown Atlanta?
No, sir.
Okay. Because Riverdale is south. I don't want to keep you out of Fulton County altogether because I think, frankly, part of Riverdale may even be in Fulton County.
Thanks.
But it doesn't seem like you need to be in downtown Atlanta.
Actually, I was working in Midtown.
Doing what?
Cutting hair at Playmakers Barbershop. That's on 564 Ponce Leon. That's not downtown area.
No, but there are a lot of barbershops. I don't know that you need to be in Atlanta barbershop.
Cool.
All right. Well, Mr. Adams, I find there's a factual basis for both your cases. It's clear, and I appreciate you being a little reserved about it, Mr. Moten, that there's maybe more to it, in particular, the case from June. Either way, you got caught with cars that weren't yours. Why you thought they might have been yours?
One car, the other one was a warrant.
Oh, you're right, it was a warrant. You were arrested.
They say they had me on film that they never produced.
Okay. Well, you're wanting to go forward today, and so we'll do that.
Yes, sir.
I also find that your pleas are knowing and voluntary. Voluntary means you're going forward because in thinking about everything that's at play, you've decided it's in your best interest to go forward.
Yes, sir.
No one's forcing you to go forward.
No, sir.
And a knowing plea is just one where someone understands it. Mr. Moten, I find you do understand what we've been talking about. You've been very articulate. You've pushed back when someone says something you think is incorrect or mistaken. So I do find your pleas are knowing. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a minor or a technical violation, you and probation will work through that. But if it's more serious, you get arrested for anything, that comes back to me. And I'll figure out what ought to happen. You didn't say anything about restitution, Mr. Jordan, in the case involving the Mitsubishi Mirage. I know that was a rental car, so Mr. Rogers really isn't going to care too much unless he was on the hook for it. No restitution there either?
No restitution in either case.
Okay. Mr. Adams, Mr. Moten, do you authorize my staff to sign both indictments on your behalf, indicating your guilty plea in both those?
Yes, sir.
Ms. Wood, can we sign for you?
Yes, Judge.
And Mr. Jordan?
Yes, sir.
All right. So, Mr. Moten, I am pulled in two different directions on this. One, you have been in the county jail for a very long time, and I know one of the gentlemen who came out here before you talked about how many times he's been stabbed there and what life is like there. It's not good.
I know that dude.
Okay. Well, hopefully you weren't one of the dudes who stabbed him because he got jumped. The other side of the equation is, gosh, you've been arrested a lot of times. And so I'm hearing you saying, oh, I've learned my lesson. I don't know how many judges you've told or how many officers you've told, hey, I've learned my lesson. You're 46. You've been arrested once a year. I know you weren't arrested when you were 2 or you were 3, but 46 cycles, that means 46 arrests. That's a bad average. You ought to be averaging where you're a whole lot more years old than you are numbers of arrests. We need to help you break the cycle. What I don't want to do is say, let's just put Mr. Moten back out there and then boom, you get arrested again. Because at some point, the state's going to do what it's not doing here, and maybe it couldn't, because even though you've got a lot of arrests, there aren't convictions, but they're not recidivizing you. When they recidivize you, whatever sentence I give you, there's no parole. You got to go away for a long time. That's not happening this time. So I'm hoping that as a barber and a son and a father, not necessarily in that order, you're going to want to take some responsibility and maybe do things a little bit differently. But that's not easy to do. I'm not saying it's simple, but you're going to need to try to figure that out. In 22 SC 184842, I'm going to sentence you to 5 years to serve 22 months with the balance on probation. In the case 22 SC 184844, I'm sentencing you on count 1 to 2 years and count 2 to 12 months. Those will run concurrently with each other. They will run consecutive to your sentence in the other case, ending in 842, and that will all be probation. So it is a sentence of 7 years to serve 22 months with the balance on probation. Special condition of probation number 1 is that you have a mental health evaluation. And if a doctor, not me, not a police officer, not a probation officer, recommends any treatment, whether that you get counseling or take any medication or something, that you follow that treatment. Special condition number 2 is that you stay out of the city of Atlanta. Just don't need to be in the city of Atlanta. You live in Riverdale, and there are a billion barbershops that you can work at, whether you start your own or you join someone else's and you get a chair, that are not in the city of Atlanta. But if the address of the place of work or the address of the home you're going to move into says Atlanta, that is not for you. If we need to modify that condition of probation over time, you can reach out to Ms. Wood and she can say, look, you got this amazing job. He's going to manage a barbershop. It's responsibility. It's a great opportunity. Maybe I'll amend it. But for now, we're going to keep it simple. If the address of the hotel, of the rental car place, of the barbershop is Atlanta, can't work there, can't be there. All right. And I'll require you at least initially to reside at your mother's house in Riverdale, and we'll get that address again so it's written into your sentence. I substituted the mental health evaluation for what you asked for. I think it's more comprehensive. Any other terms of condition, terms of probation you want to see, Mr. Jordan? I'm going to ask Mr. Moten in just a moment about his sentence, but anything you want to add or subtract from the sentence, Ms. Wood? Mr. Moten, you asked for time served. The state asked for 6 more months, and I'm giving you a few more months. So I'm coming down somewhere in between. But what I told you at the beginning remains true. You can say, Judge, I appreciate you're somewhere in between. You're trying to be fair and balanced, but you know what? I'm not interested. I'm going to withdraw my plea and stay right where I am, because you'll stay right where you are, and see what happens at trial, which will be 3, 4, 5 months down the road. You can figure that math out yourself, but I need to give you the opportunity to say no thank you, because I promised you you'd have that opportunity. And if you want to talk with Ms. Wood about it, you can do that as well. But you understand the sentence that I'm imposing is less than what the state asked for. It's a few months more than what you've served.
Could I ask you a question, Your Honor?
Sure can.
Would that be like, with me like at 18 months? Would that be like?
So you've already done 18 months?
Yes. I was locked up on August the 8th.
You'll get credit for all the time you've been in. If you've done more than 18 months, I'm not sure.
It's like at 18 months, a little over 18 months. I mean,
it is a little over.
It's a little over 18 months. I mean, would that be like 4 more months? What you're asking for?
Correct. The most it would be is 4 more months.
In the county, or?
It's a great question. I don't decide that. The sheriff would say, you know what? it doesn't make sense to transfer Mr. Moten to Department of Corrections, because by the time they go through diagnostics and everything, they're going to say, we're going to parole him. So I don't know how that works. The sheriff decides. I know the jail's very full. And so the sheriff's team may say, whew, get him to Department of Corrections. In some ways, that could be the best thing for you, because they're going to say, what? 4 months left? Parole, and you'll get out. I'm not promising that. I don't know. They may say, look how many arrests he's had. You're going to
No
do
more than 4 months, though.
no more than 4 months. Maximum would be 22 months, and you've already done 18. So you did the math in your head, and you've actually done more than 18.
So
So
the
it's,
remaining balance is
So it would be 7, first probation, serve 22 months, the rest would be on probation.
That's so much probation. Wow, that's a lot of probation.
so Mr. Moten, on the probation, if you are doing well, probation will petition me to suspend it. They don't like having to supervise someone who's doing fine. If you are getting caught up in little things where you're driving someone's Dodge Caravan that you bought for $60, then they're not going to want to suspend that probation. So it is probation for a while. But frankly, I am agreeing with Mr. Jordan. It's mostly to make sure, let's get you situated. And if you go a year, 18 months, 2 years, no arrests, everything is good, then Ms. Wood can reach out to say, hey, Judge, could we make it unsupervised? Could we terminate it? And I will look favorably upon that. But like I said, 46 arrests, 46 years, you need to convince me that you're going for a while without any issues. Does that seem fair?
It seems pretty fair. I can't complain.
Okay. Do you want to go forward with this, or do you want to withdraw?
I would.
Well, let's do it then. I will sign those final dispositions. Again, I don't know whether you'll go to Department of Corrections. It could be that actually the sheriff talks to the Department of Corrections, and it's never the sheriff himself, but his team, and they say, let's just release him now. But I don't want to promise you that. Like you said, the most it would be 3 months and some change.
Could I mention one thing to you?
You may.
And it didn't transpire in your courtroom. I have a case that was thrown out months ago. She just sent them an email because it's still posted in the system. Could you have your influence or any kind of help on that?
So I have very little influence in life, but what's the case number?
Judge, it is going to be, I think it's 21 SC, one moment. It's out of Judge Krause's courtroom, 21 SC 179931. I suspect, and I did tell Mr. Adams or Mr. Moten that I believe it's probably a clerical error with records. I'm gonna send them this order showing that it was dismissed.
Okay, it says closed. So I don't know, where is it saying open?
On the booking screen.
Oh, on the booking screen. Okay.
Like if I ask the officers or whatnot, what's going on with my situation at the time, they tell me that, but I was like, I've been kind of confused.
Right. No, there's
it was thrown out.
Yep. I'm looking at the order that Judge Krause signed in August of last year, dismissing the case. So it is officially closed. We can fix it with the booking screen so that that's not something that's holding you. Okay.
Okay, I just don't want.
All right. Ms. Tucson, do you need any information from Mr. Moten?
I mean, I can get that address. I started to take it down earlier, the 6510.
River Park Drive.
Is that Clayton County?
Yes, ma'am. That's Riverdale, Georgia. Clayton County, Riverdale, Georgia, 30274.
So 6510 River
Park Drive. And if it changes in between the time for me being from now and being released, who do I contact? Miss Woods, or who would I contact? Because she was in the process of
contact probation. Do you know where probation is? In Morrow on Citizens Parkway?
No, ma'am. But I can. I'll pull it up. I'll make preparation for
Miss Wood. I can forward it to her.
Okay.
And is there a contact phone number you'd like to put down?
Ma'am?
You said?
No, I'm smooth.
Say that again. Yeah. Ms. Nelson's going to email Ms. Wood about getting that closed case off your booking screen.
Thank you.
Okay.
Thank you.
Mr. Jordan, anything else?
I was just trying to.
All right.
I'd like to. Thank you, Judge.
You're welcome. Thank you for jumping on those two. No, it was stay out of the city of Atlanta, which covers every hotel in Atlanta. So I need to go in a couple minutes to a lunch meeting, and then I will come back, I promise. But I don't want to keep folks around. If there's a plea, I can't do that yet. We can do it when I get back. If it's less than a plea, we can take care of it. I need to tell Ms. Craig what's going on, so we'll do that because then she can go. But Ms. Primovic, what did you have left?
Mr. Carbo will be a plea.
He will be a plea. Okay, can we do that after lunch? I'm sorry to keep you around. Okay, and then Ms. Dyson, is that is that a PD case? It says Stephen Lang.
Yeah, that's mine. That's Mr. Feely's, Your Honor. We were hoping for something today, but wasn't able to.
Okay. Let's, so do you want
That
to?
was waived, Your Honor.
That was, she did waive it?
Yeah, that was waived, filed the 16th.
Okay, great. Then if you would bring Ms. Dyson to the door, I'll talk with her real briefly, and then we can bring the other female, and then we're gonna break for lunch. And we'll do the plea for, I know I have a motions hearing, but we'll do the plea first on Carbo. You guys can draw straws as to which PD sticks around for that. And I think that covers everyone on the calendar. Unless you've got pleas from the trial calendar.
That's for tomorrow, right?
That's just what tomorrow is for, to be fresh. Hi there, are you Ms. Dyson? Hi, I'm Judge McBurney. Nice to meet you. Your lawyer, Ms. Feely, has already filed the paperwork that we were going to cover today. Today's just plea and arraignment. And Ms. Feely, hopefully she's talked to you, whether you met face-to-face or it was on the phone. She waived your arraignment, which is simply she entered a plea of not guilty for you. She wasn't able to make it to court today, but I wanted you to know we really shouldn't have brought you over, but she forgot to tell us that she had waived your arraignment. So that's what we would have done today. Ms. Feely would have said, Ms. Dyson waives arraignment. This guy, the prosecutor, is going to get discovery to your lawyer. That's all the paperwork in your case. She'll read it and come meet with you to talk about how good it looks or bad it looks and help you come up with a plan for moving forward, whether it's filing motions or trying to work the case out or going to trial. And that's when I'll see you next, either because there was a motion filed that your lawyer needs to argue, or there's a plea, or it's trial time.
I was wondering, she did come to see me face to face. When we had talked, she kind of did make it seem like though that I was still supposed to come here because she did put in a motion for a bond reduction.
Okay.
So I didn't know if that went through or not.
It's not on today's calendar, but if she's filed that, she'll reach out to Ms. Nelson and we will bring you. So that's a fourth reason I'd see you. And I'd see you much sooner for that if we're going to hear that bond motion. The state needs to have notice because they need to be able to contact the alleged victim in your case, should that person want to say something about bond as well. So we'll see you soon if there is that bond motion there. Ms. Feely will be here for that and we'll talk about that. And then all those other things will come afterwards, okay? All right. See ya. Yes, please. So I don't know why that woman entered the appearance. She's not in our court. Maybe she was non-complex or something. It's not a non-complex case. Is Ms. Craig's case one where we should try to get Joy Walker to talk with you or not? I've already been in. All right. Has she reached it? She's been getting a few cases recently. Has she reached out to you on some? Okay, good.
Oh, yeah. That's
Okay. Hey, no, Ms. Craig can just be right there. I can see her better if she's right there. I'm sorry to keep you standing, Ms. Craig. I just want to introduce myself and let you know what's going on. I'm Judge McBurney. Your case has been assigned to me. And we're trying to figure out who your lawyer is. There was a Ms. Smith who had filed an entry on your behalf, but Ms. Smith actually works in a different courtroom. I think she was confused as to where your case was going. So your lawyer is a gentleman by the name of Eric Johnson. He's a conflict defender because the public defender represents your co-defendant, Mr. Arnold. Mr. Johnson, unfortunately for you and for me, is working on that YSL case. I don't know if you've heard about it, but it's the big gang case that's supposed to last for many, many months. So Mr. Johnson is effectively checked out because he's busy doing that. But that's not your problem. You have a case you've been in jail for a long time about. Yes, ma'am. And I'm reaching out to Mr. Johnson's supervisor, Ms. Walker, to see if she will talk to the prosecutor because he's told me, gosh, Ms. Craig's been in for a long time. We may be able to resolve this. And then Ms. Walker will come visit you to see if it's a case that can resolve real easily. If it's not, if it's complicated in some way, that's really not her role. She's a supervisor, and we're going to work to get someone to take Mr. Johnson's place on your case because he's your assigned lawyer. But as I said, he's stuck doing this other stuff. So I just wanted to give you that update, and don't be surprised if someone named Joy Walker, Ms. Walker, comes to see you. That is someone who's advocating for you. Okay? Any questions?
I'm just ready to get out of here.
I figured as much, given how long you've been in. So I'm going to try to convince Ms. Walker to go see you, and then we'll see what can happen from that. Okay? Well, you will if it's going to resolve. Ms. Walker doesn't just hand you a key and you get out. She'll talk to you about how you could resolve the case by way of a plea. But she needs to talk to the prosecutor first, because if the prosecutor's saying, sure, she can plead to 100 years, no, you're going to go to trial. But if the plea is, I'm making the numbers up, 2 years, well, dang, you've almost done 2 years. So maybe there's some middle ground.
Anyway, I have to represent myself.
So you should start with Ms. Walker, okay? And let's see how that goes. And if that doesn't go well, then we'll have that conversation. But self-representation is generally a bad idea. Not because you're not smart, but because you're not a criminal defense lawyer, unless I'm mistaken. Okay? So I will see you soon after Ms. Walker connects with you. Thank you. All right, with that, I got to scoot. I will be back a little before 1:30. We will do Mr. Carbo's plea, and then we'll take up our motion for which we need an interpreter. Okay, thank you, everyone.
Mr. Peter, you
Let me check. I feel like it hasn't, but I want to double check.
things I can do.
What is it? I know. Crazy. I think I left it in my car. Yeah. Julian, I just sent an email. If I get an answer this afternoon, I'll just send you the update.
Gotcha. Okay, I appreciate it.
But Mr. Price is good to go.
Good to go. Okay.
Mr. Humphrey also should be good to go.
Okay.
Do I have any others that were like potential pleas with you tomorrow?
I think that may have
I'm
been.
gonna go. I thought I had my list with me, my calendar, but I left it. So I'm gonna grab it
Gotcha.
when I get back to the office, and I'll send you any other updates.
Right. I think that was it. Major Edwards is yours. Danny Jones is yours. All right, Miss Edwards.
It's Edwards, the newlywed.
That's the last one. And she, of course, she has the two positions. You think if I was able to get the okay to do just tend to serve one on that one with the delayed like reporting, you think you would take that?
I will convey.
Okay.
I don't know, but I'll let you know.
That'd be fine with me.
Okay.
Yes, there's a whole bunch. I can forward you everything.
I have an email that I just printed off.
Okay.
I'll bother you after lunch.
I
don't want you to
appreciate
do work that I'm already.
I got you. Yeah, so it's, I think at least Danny Jones, Christopher Coleman, and there may be a few others. It's at least 4. So make sure to bring my water and my chapstick for tomorrow.
A lot of talking.
Yes, a lot of talking. And I will see y'all after lunch.
Okay. So we pick a jury on Monday. Hey, I got called in for jury duty in DeKalb.
No
Too bad that they have black mold and they're not doing anything.
Oh
So I
my
had
gosh,
that
I
water
forgot.
leak.
Yeah.
Seeing you.
Oh, absolutely. Wait, so do you still have to show up?
I don't know. I got a call that Sunday.
Yes, so, because 27th is Monday, right? I think. So what's left? A plea? Okay. I thought I had my calendar tomorrow with me, and I don't, so I need to go.
Just gonna do my work from there, so.
Smart, very smart.
You guys do anything fun?
I think I told you I'm doing like a hiking challenge. Did I tell you that right? Yes, how'd you guys go? Okay, so.
We can hit Sweetwater kind of, or the, whatever the one, I-20 is.
Yeah, going west.
Yeah, that's the.
Sweetwater, I need to go there, I haven't been in like a year or two. That was super fun though. So I found a new. You know how like, when you can go. And it's all you can go just the mountain.
Right.
So Kelly is like.
Yeah.
Situation.
I like Chatham Hill. Chatham Hill.
Yes, I don't even know.
only.
Any knowledge, 36284. Sorry, you saw that?
Hey, what's going on? Hey, Rosa wrote this. She's here, correct? I just got one page. Thanks for asking. This judge. We done? Good having Mr. Jordan, was it? I'm Eli.
Oh, nice to meet you.
Nice to meet you too.
Yeah, so.
What about tier one?
When she didn't serve,
She was probably the wrong.
in a year.
She might take it, I gotta talk to her.
Yeah, she must be tier one, yeah.
Y'all can do a tier one?
Yeah.
Let me ask her about that.
Okay. Okay, cool. But yeah, let me know.
All right,
Okay.
I gotta get the interpreter up here first.
I got you, that's right.
Too important for my crappy.
Understood, understood. Hey, man. Good to see you, man. What are you here for?
A motion was made, we don't have anything to be heard.
Okay.
Yeah, it's SB4.
Gotcha, okay.
So it's with Kim Carey, but I think she's out for a while, so we'll switch it over to her.
Yeah, it's like 8 departments for me, so.
It's all good. You know, it's a great case.
Gotcha.
Those fun ones.
Brianna told me y'all talked the other day and,
Yeah, she texted me about today, I just couldn't help her. I saw her in Dallas.
yeah.
See if we can really enjoy showing it.
Yeah. She did, yes, I think she was always gonna put that's where.
Those are my favorites. Yeah, no, we talked about that. Over time, we will flexibility. Sometimes,
Absolutely.
sometimes.
Yeah.
It's raining today.
How's the family?
Good, good, good. Good problems are good ones. Yeah,
Don't live that area.
yeah, we really. Yeah. Well, suburbia.
Thanks.
We liked it, we liked it. Which I
Just a motion. But I'm starting to school now, so.
really. Is it you and who else?
Just.
Just you?
Well, they got you, especially.
Oh, yeah, yeah. Special.
Talk about.
She's in. She took a chair, that's just. Yeah, or she might be a PG.
Sure, I know. I think she left right before or something.
Sounds right. Who the PD to?
Lacey Wood and it's Leaf.
She was my lead. We went to law school. She was me.
Oh, yeah.
She's supposed to be.
Yeah, she's out.
Yeah. At law school, it was a PD. Here. He left. Devin Franklin. If you ever met him. I know he was in front of Eric,
Still here, still.
yeah, he's a judge here. Dunaway.
Dunaway, yeah. That was.
He was a ADA.
Was he before he was an ADA or was it after?
It was child murders and pending here and they said a judgment. I think Eric followed it. When Eric started in. You know Julie Kurt? Yes. That's his name. Wow. Kind of much, yeah.
And so it was. We were just wait. We had motions by still the officers. From one of the APD and I was asking.
What about the GBI guys? He's MIA too, right?
No, he's available. I was gonna tell you about that. He wants to come in with the mask on because he's still undercover.
I bet he does. Yeah, stuff he's been pulling out there on the street.
Right.
Setting folks up.
So they're watching people.
He's the guy with the long hair, tattoos, right?
Yes, and he had the black mask on and the camo pants, I believe it was. Yeah.
Did they ever find out who the guy was that peeled out and they busted my client up? I think that's the informant, the detective. And he's the guy that didn't deal with, and then my client's the schmuck that shows up with the drugs. I don't even know
much effort there was to get on the truck.
No effort.
Yeah, Crenshaw just pulls up, they're probably told, okay, container, so.
Crenshaw was pretty cool, real, he was honest about it. I was surprised, well, I guess I should never be surprised when the case gets found over, this one particularly thin, when all you got is Crenshaw.
Yeah, I mean, we do have a fee, I don't know about the other DUI,
And then there's the canine officer, that's the seal. I messed up in my motion, I thought the dog's name was the seal.
Right.
I was. Because it didn't say in the report, the dog's name was like Rover, I don't know.
He told me, recently, yeah, he was ready to come, he's still with it. So he was in here, but,
It wasn't gonna be a particularly interesting, I think that the APD dogs are pretty well trained, as opposed to state trooper dogs, which are garbage.
just wish they would have gotten certain ones.
Would have been easier, would have been less for me to argue about, but I still don't think the suppression issues are the best suppression issues. They're not terrible color. But the dismissal motion, I mean, I guess my curiosity would be, what was the reason?
Yeah, I'm not sure, especially when we have those probable cause hearings, there's not much documentation they put on it. So it's like up until right before it's buried. So.
Right, because we didn't even get a prelim for over, which is unusual. I mean, I had to take 9 days or something, days, not a year. So
I think it may have been because they issued.
Went a different track.
And when they don't have bond, then normally the cause hearing pretty quickly. We had motions to reduce the bond, so I'm sure
3 times.
Yeah.
And each time we were denied. And then I subsequently learned that the magistrates, they didn't bother to tell us this, but their standing order only allows them certain amounts of discretion. They're limited. They're not allowed to reduce the bond. Somebody had told us that, maybe we would have been a lot like quicker. We might have had a better chance of getting a reduced bond, but frankly, I don't think there's any bond she thinks. She has her family. Everybody's next.
Yeah, she wants to take that to her.
Yeah, how long after, I know, how long after, when you guys know who's going to be.
It's a major case, we know pretty quickly. It's another, it's a big shocking distinction, but it's just a burglary.
How long is that so good?
One in the Bible. Does he have, previous conviction?
He's got another case.
Like, okay, that's
right. I mean, what we have. Basically, turns it down.
That's a clever scam. How long did it take for people to find out we didn't are they?
That's what we asked.
Are these lease drive-offs from Canada where they're actually altering the VIN numbers and all that? Or is it?
I haven't got that for you.
Because that sounds like we've run into a bunch of handful of those where someone buys the car and it has a salvage title in Texas. And it's all from the same dealership.
Oh, there was a rash grab in Texas. I didn't find that false arrest because he had a temp tag from Texas.
Right.
It was legit.
Right. It was, and even if you bought one of the stolen ones, you know, you're a bona fide purchaser. There was no way for you to necessarily know, yeah, it's a real good deal for a car, but you assumed that it was trashed in a hurricane, you know, flooded out or whatever, and it's been rebuilt, so it's a reasonable discount. We had a couple of those. It turns out there's I think there's at least 2 VIN numbers. There's the original one, like, or the one that's publicly available, it's on the dashboard, but you can easily also use the factory VIN. on the engine block, and those are the ones they were checking. Oh, wait, this car's stolen. With false ID, somebody leases, Mercedes or whatever.
Gotcha, cool.
Was this at 1:30?
It's at 1:30.
Oh, that explains. I had it at 1. I did too.
Yeah, I only knew that he said 1:30 because we had a calendar.
Okay.
So.
They probably needed a break. That's understandable.
Yeah, he's still doing this from Bentley dealerships here. Was passing out to the next person in alternate and moving it down to New Orleans and Texas to sell vehicles. And he did 18 to 12. I think he did about 2 years in custody. I'm sure we still want to proceed forward on our case because this is actually the exact same story. It's pretty good, right? There's no restitution either. These were Bentley GTs. These were about $240,000 vehicles.
Did the purchasers lose the cars because of it?
Yeah, well, they only found one of the vehicles in Texas. It was like 18 vehicles sold. So.
The one that had more runners, where's that at? Drop off family's house is friend all problems.
Oh, you seized it?
Yeah.
Seized?
Yeah. I think they were able to return back to
Yeah, what does happen? What happens to the buyer? I guess they're out of money. There's no restitution to that.
There's no information that we have who bought that.
Yeah. What if the Bentley dealership got reimbursed with insurance proceeds? And they double dipped if they got the car back too.
Yeah, that may be why, because I was confused with why it's part of his federal sentence and this kind of restitution is part of that release column.
I feel like if another dealership got reimbursed with insurance and the buyer should get.
No, yeah, absolutely.
I guess they're, that's three quarters of the suit.
Yeah.
Give me my car.
Give me the car or give me the money that you got, at least reimburse me for the difference.
Yeah.
That's whatever you got from insurance and what I paid the fraudster, because you're at least partially responsible by negligence for allowing this fraud individual to lease this $300,000 car with fake ID.
Biggest problem is restitution. They're not committing those crimes because they can pay.
Oh, absolutely.
They can pay restitution, they won't be committing those crimes.
Yeah. We got a lot of
Someone gets screwed.
people running around.
Someone gets screwed, it's usually gonna be the buyer, it's gonna be the person who least before they get screwed, outside of the person who commits the crime.
Yeah, there's no way, he had a fee as well, so I'm sure there's no way he would be able to pay 10% on one of those crimes.
I think I should name it. Not buying your own middleman or anything.
Especially at that way, you have to.
Yeah.
Some, yeah, it's too good, sounds too good to be true, it probably is.
2-year-old bet now, getting $50.
Yeah, that don't smell right. Who is your supervisor?
It is Rashandra Davenport. She's essentially the number 2. The number 1 is George Jenkins.
Ah, okay. So she said no to suspend it, but okay to zero.
Yeah, just because she felt like the amount of drugs, but I explained to her, I said, it's very clear that she may not even been a mule, it's going to be the middle person, or the third person. She wanted to know if there was an information
Oh. I wish I had something other than just my word. I can tell you that my practice deals 95%.
That's what I was saying, yeah.
And most of them are undocumented. She has no remedy, and I believe she's been removed. I think she got removed once before. She's at least she's been caught at the border before and put into removal proceedings. So she probably has an order of absentia floating around out there. A lot of times when people cross the line, they get caught, fingerprinted, given a notice, but reported, yeah, and then they again, they're in proceedings already. So someone's even fingerprinted and released in the United States, depending on when this happened, which administration we're under. So I guarantee you she got around out there, has zero change. I think that would move.
Yeah, absolutely. I think that, and I know, that's fine, exactly. Started out with the resolution, they would want us to look at months, 29 days, and it says, this is because it was my understanding that anything about the 12 months or to get tried.
Yeah, it makes it, the 12 months makes it an aggravated felony, even when it's a misdemeanor for the INA, it's an aggravated felony, especially for domestic violence, battery, disorder, even disorderly conduct, potentially, shoplifting, stuff like that, that would all be problematic, it's 12 months. Right. But for her, I mean, she's got no belief in a conviction for traffic, for possession of intent, or any drug possession, even simple possession. That would make her statutorily ineligible for immigration law, ineligible for employment.
You guys get appointed?
No, we get hired. We got hired by our family in Mexico. So we've got an attorney from the city. He's not part here, but he has a lot of connections. He's part of some people in South. Or afternoon, I guess. But you think if, I mean, I guess I don't have any way to prove it without, going through the FOIA process, which takes 6 months.
I'm not sure of why she would want that. I'm pretty much sure that it's actually. Okay. That's what I want to say. She's absolutely. So.
I mean, if the case gets dismissed, no matter what happens, she need to, and I don't know if this was for any, but a condition of censor probation and put a condition, I've done this before, it's not just suspended sentence merely on your way. If you return to the United States illegally, it's a violation of your probation conditions. If you're found in the United States, then you're looking at 10 years.
Would it have to be before the measurement of this?
I've had people report from Mexico by phone or mail. I've actually had that happen. But yeah, I guess it would have to be, I guess it would technically be a suspended sentence. It would be resurrected if she's caught inside the United States. Maybe probation would be the right word for it.
Yeah, that was I understand the conception, but I think it's actually different branding. So very much it's how the word is used.
Right.
But I didn't have issues. I think what she's doing. Sometimes it takes till, and I'm sure I can attest to it, since it takes till it's on the trial counsel for them to really understand, because if it's not a precedent thing, then they're just kind of, it's like, oh, no, right now, and then it's the weekend before trial.
Right. Exactly, but then suddenly they're way more willing.
Right, and then it's a lot more flexibility. So I would like to be done early.
Yeah, that would be nice.
Detailed email from Peter. There should be some of those letters.
Oh, absolutely.
Yeah, absolutely. They all show up.
Yeah, hopefully they'll try. I think with Stephen, I think already been accepted, say Randy Jones, Christopher Coleman as well. So hopefully those two, at the very least, the units that get close tomorrow.
Okay.
Well, let me ask you this.
Yeah.
If you move forward with the motion to take the loss,
I think that we are we have status now for 50 and it's for trial. 27th, so
Okay.
Yeah, I'm very willing.
Okay, that sounds good. I guess we'll go forward. Right, it's factors, right? It's really not a lot of evidence.
Gotcha, yeah.
Other than just a record procedural posture.
Right, that was gonna be me too, it's just some sharing, so others. I think it's like, jurisdictional statutes and stuff.
And that's the point, that there's not a whole lot of guidance in terms of timelines that are, it's just, it's unusual, this was an unusual enough case. I've actually had one other motion in this speech trial, also a drug case, actually won, and it got reversed by the court. It got reversed by the judge, who I'm sure you're absolutely, so a little bit of shock. Anyway, that's, the reason why the judge dismissed it, because DAs are also actually decide which case to call in for trial. And that's not a totally off the wall process to give the district attorney's office that much discretion. But they can't call cases out. Yeah, so my case was older than 3 or 4 cases that went out before mine. And I showed up at the counter call objections and I'm ready for trial. Then the day, but the trial, I just got done with the trial. Then suddenly my case gets called and followed on Friday. DA had that on purpose because he was trying to let me down. I was tired, he was trying to see that. So the judge, that's not that. It was way more egregious than this. I mean, that was strategic on the part of the state, and this is at worst. I'm gonna use it. It's not used. No, it's just a system in general.
This is a full county issue.
Right.
By the time it gets to me, I have no idea what transpired.
No, you had nothing to do with that. So I get that.
Okay, yeah, that's cool. They stay within the tier of the so now people that didn't see it.
Yeah, because I can get information from Sam. I'm not sure whether we have a should be able to find out if she already has it. Because if she does, then that's even that'll make it done. Sure, I mean, just even if she was from a resident, she would certainly not eliminate prospects.
So she would possibly have. I believe what you're saying. Who choose? It's to.
Nothing that I would expect anybody to think is. I think it's truthful, but that makes sense. They did a job long people from stuff through multiple layers of. It's not a coincidence that the guy that says he loves chilling in the parking lot watching her get arrested.
Yeah, I don't understand. They just got these Gonzalez where they speak about the truck.
The only explanation I could give, and not so much conspiracy theories, is that that's the guy. Which means why aren't you working him and squeezing him to get further up the chain? What is arresting her about? That shows that it's essentially nothing. And,
The speedies have started to come now. Oh, now they?
and it's almost like you see a level of collusion. Concern about it, people there.
Mr. Carbo?
Is that it?
Unfortunately, yes. We have great hopes for tomorrow, though.
Great hopes for tomorrow.
Yeah, I don't know how many hopes we have for tomorrow.
At least 4, at the very least.
At least.
At least.
Okay. Is Carlo putting for all the charges or some of them going?
He is done.
It's going to be a dismissal of count 3, which was the disorderly conduct, and count 1 will be reduced from felony obstruction to misdemeanor obstruction.
What's the code on it?
I believe it's the same code. I can definitely make sure for you.
And count 2 is gonna stay the same?
Yes. And it is still 16-10-24.
Who has the Baxter Ross case?
That is 88 White now. And he has both of them. I thought that one of them was mine, but it's apparent he has both of them.
It was like, okay, I love it. I got a second one. You busy, huh? Oh, he's so sweet. What you did?
I didn't ever get out and run around people.
Said, I don't wanna do, I wanna do what I wanna do. We have an interpreter.
I haven't seen her yet, but she is needed for my case.
Right, I think she's scheduled for 1:30, so
Okay, cool.
I'll reach out after
Okay.
he gets, because I think he said he was gonna do the plea first.
That sounds good. Thank you.
I have a question for you.
Yes.
Since Stanley is also known as McBurney, he said his name is Stanley. What do I remember? As the city.
On the plea. Whatever's on the indictment, I'm sure they'll send.
Okay. Okay. I just wanted to make sure. What was his time?
Like a year. I wouldn't have used his name as an name. Yes, right.
Name and I don't see the one on the indictment, right?
Stanley Adams.
Okay. That's
And
what I was,
that's
the other name you gave, they were rejected. That's what I was thinking. Okay. All right, well, thank you guys.
Did you do a plea today?
Yeah, he did. He did plea on both of his cases.
Oh, that was that guy, yeah.
Oh, okay.
That guy. No, that was not him.
Oh, okay. Well, that's good.
Yeah. Gotta be careful when you use AKAs.
You don't know what you're getting.
Maybe Reverend Purple, I remember Judge Lovett back in the day going, unless you're using Jesus Christ. Well, you know this another.
Yeah, we. You don't know what you're getting.
Yeah, you're getting.
Especially the brothers that use their other brother, you know, the good brother and the bad brother. Yeah.
And then
Yeah, messes up. Yeah, that's horrible.
That's
It's
terrible.
like,
All the people.
I'd be so mad.
Well, what Pilgrim said? What Pilgrim said?
Where's Pilgrim at?
Said what he said.
She don't go.
Oh, so they approved it. She said she didn't do their approval.
Yeah.
Oh, I have a key.
Correct.
Yes.
Still waiting on that. We're good? All right. Thank you so much.
You're welcome. And the name of that client again was?
Malik Henderson. Free number 1, I think I saw him, or somewhere near there.
So he was in jail?
Yeah. He's in the top, yeah, fifth grade over there.
Oh.
You don't have to
Don't
do that. I asked him, he's not here.
Oh, okay.
So he's not even going. Okay. Thank you so much.
You're welcome.
What's his name again? I can really take care of that.
All right, that'd be good to see you.
So office, I'm pretty here. Because you know what you
Hold on, one, right here.
All right, I'm sorry, I'm late in returning. I meant to be early so we could cause the Gonzalez matter to be as non-late as possible, but I have one plea I need to take first. Maybe they broke the news to you.
That's no problem, Judge. We're still waiting on the Spanish interpreter.
Well, look at that. Doesn't mean I should have been late, but if Mr. Carbo, are you ready, Ms. Primovic, for Mr. Carbo? If we could bring Mr. Carbo out, please. We made inquiries with, I guess if I wasn't here, you didn't mean to, okay. Ms. Rivers, you ready? All right. Are you Mr. Carbo?
Yes, sir.
Hi, I'm Judge McBurney. Nice to meet you.
Nice to meet you too.
Mr. Carbo, your case was on the calendar for plea and arraignment, but Ms. Primovic tells me that you might be ready to enter a plea in your case. Is that correct?
Yes, sir.
So in a moment, Mr. Jordan is going to put you under oath and ask you some questions. I'll need you to answer those truthfully and completely. I also need you to ask any questions that you have. So if we're talking about something and it doesn't make sense or you're confused by it, will you let Ms. Primovic or me know?
Yes, sir.
Mr. Jordan, is this a negotiated plea?
It is, Your Honor, and it would be a reduced plea, and I'm sorry, Your Honor, I apologize, it's not a negotiated plea. It is it still not negotiated?
Correct.
Yes, my apologies.
That's okay.
And also, count one, which is currently a felony obstruction, the state has agreed to reduce that to misdemeanor obstruction.
Keep going. I didn't mean to interrupt.
And also, count three, the disorderly conduct, the state will need to dismiss that count. So it will be a non-negotiated plea as to counts one and count two.
So misdemeanor plea, 2 misdemeanors.
Yes, sir.
Got it. So Mr. Carbo, couple things. One, if you could not jingle your chains, that would be great. Just because it's going to make it harder for the court reporter to hear. So you get them in a good spot and leave them. 2, this is very early in the process. So I'm going to hear from both sides. I'll ultimately pronounce a sentence. If the sentence that I give you is more than what Ms. Primovic has asked for, you can withdraw your plea. You can say, you know what, Judge, I appreciate that, but I just soon have my case go forward. I don't want the sentence you gave me. So I'm going to give you a chance after I pronounce the sentence, if it's different from what Ms. Primovic is asking for, to talk with Ms. Primovic to see, you know what, it makes sense. Let's just take this. Even though it's not quite what I asked for, it's close enough and I'm willing to take that. Does that make sense?
Yes, sir.
So just to make it up, the most I could give you, most would be 24 months in jail. You've already been in jail for a fair amount of time, but let's say I gave you 24 months in jail. Say, wait, that's not what I asked for. No, thank you. And then you could withdraw it. No one would know that you ever tried to enter a guilty plea, and we move your case forward. But if I sentence you to what your lawyer asks for or less, then you are bound by your plea. Okay?
Yes, sir.
Great. And I'm not trying to be vague about what I'm going to do. I don't know anything about you or your case. I'm going to learn about it from both the prosecutor and from your attorney. Then I'll be in a position to say, I think this is the right sentence for your situation. Okay?
Yes, sir.
Excellent. When you are ready, Mr. Jordan.
And also, Ms. Nelson, I do apologize, 16-10-24A is the misdemeanor.
Okay, thank you.
My apologies, Your Honor. This is very slow. Mr. Carver,
Yes, sir.
raise your right hand. Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand.
Thank you.
Can you please state your true, correct, and legal name?
I'm Nathaniel Carbo.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Yes, sir.
What medication are you currently, I'm sorry, are you under the influence of medication?
Yeah.
What medication are you currently?
I don't know the names. It's new ones.
Okay. And what do you don't know the name, but do you know what you take? For
Yeah,
medication?
for bipolar.
Okay. Does that medication that you take help you to understand?
Yes, sir.
Do you know the dosage that you take?
No, sir.
Is that clear enough for the?
Sure. I'm going to ask a couple more questions, Mr. Carbo. So have you been taking that medication as long as you've been in jail?
Yeah.
Were you taking it before you were in jail?
Yeah.
Okay. Same medicine, or did they change it when you went to jail?
Same medicine.
Same medicine. And did you mention it's 2 medicines?
Yeah, like 2.
But they both help with bipolar.
Yes, sir.
Do you take it in the morning or at night?
Morning and night.
Both.
Yeah.
Did you get it this morning?
Yes, sir.
Okay. And when you take the medication, does it make it easier for you to understand what's going on, or does it make you woozy and drowsy and confused?
Makes it easier.
Okay, great. Well, let us know if at some point you're not understanding what's going on.
Yes, sir.
Great. Thank you, Mr. Jordan.
Mr. Carlo, how old are you and how far have you gone to school?
I'm 33. I'm 11th grade.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the offenses of obstruction and criminal trespass?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? If you plead not guilty or remain silent, you will receive a jury trial.
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Primovic, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Primovic, do you waive formal reading of the indictment?
So wait.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Carlos' name?
Yes, sir.
Mr. Carlo, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Ms. Primovic, do you know of any outstanding warrants?
No, sir, we do not.
Mr. Carlo, has your attorney advised you the minimum and maximum sentence for each charge that you're entering the plea to today?
Yes, sir.
And Your Honor, since these are both misdemeanors, the minimum is 1 day in custody and the maximum is 12 months for both counts. Do you understand that this is a non-negotiated plea and the state may still recommend the sentence to the court?
Yes, sir.
Have you been made aware of the state's most previous offer in this case?
Yes, sir.
And Your Honor, just for the record, the state's most previous offer, and which will be the offer for our recommendation for a non-negotiated plea, is a total of 24 months to serve 7 months community time served, with the balance being probated, with the only special condition of probation that you not return to the incident location.
Which is the Waffle House you'll tell us about? Okay.
Mr. Carlo, do you understand that the court can impose any sentence authorized by law, including a higher sentence than recommended by the state, up to the maximum of each charge?
Yes, sir.
Do you understand that if you, Your Honor, you've already explained to him that he can still withdraw his plea?
I have. Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal list?
Yes, sir.
Do you understand that if you are placed on probation, you cannot violate any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health offenses, by answering the plea guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself.
Yes, sir.
You understand that by pleading guilty, you're giving up the following rights, which I will list off. The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney in the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you were in fact guilty?
Yes, sir.
Mr. Carwell, how do you plead to the charges of obstruction and criminal trespass in the indictment of the 23 SC 18577?
I plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
You understand that you only have a limited right to appeal this guilty plea?
Yes, sir.
You understand that since these are misdemeanors, you only have 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty.
Yes, sir.
Your Honor, for a factual basis, on July 8th of 2022, an APD officer responded to a criminal trespass call at the Waffle House located at 135 Andrew Young International Boulevard. Dispatch advised that the suspect was a black male wearing a turquoise blue shirt with black pants trespassing on the property using to leave. Upon arrival, the responding officer, who is Officer Roach, located the male. They identified as the defendant, laying on the ground near the entrance of the Waffle House.
Outside or inside?
I'm sorry, outside.
Okay.
The defendant was asked to pull his pants up and leave the property. And Your Honor, it's pretty clear from the body cam video that it wasn't anything, because he was originally charged with public indecency. It was just that Mr. Carbo's clothes were too large for him. He was struggling to keep himself covered because his clothes were so large. APD warned the defendant that he had a prior trespass warning at the location and he could not return to the property. The defendant responded with expletives saying, beat your ass, punch you in the face. When the defendant was told that his not leaving the property could result in him going to jail, the defendant became very combative towards the officers, saying, "I out to jail, I ain't going anywhere, F you." The defendant started to walk away from the location and stopped, faced the officer, and assumed an aggressive posture. The defendant repeatedly called the officer names. The officer warned the defendant several times to not ball his fist at him. According to the officer, he continued to ball his fist. This did lead to the defendant being tased and also then arrested for the offenses of criminal trespass after being told to not return to the Waffle House, and also for the offense of then felony obstruction, Your Honor. Your Honor, that concludes the factual basis for this plea. I did reach out to Officer Roach. We had no issues with the felony obstruction being reduced to misdemeanor obstruction. In fact, Your Honor, I believe that it probably should have been charged as misdemeanor obstruction the entire time. There also was a note that they could not find any documents that said that there was a criminal trespass warning previously, that it was just a verbal criminal trespass warning. So the reason for the state's 24-month recommendation is just to make sure that Mr. Carbo stays away from that particular location, and that we can monitor Mr. Carbo, because I do believe that there was a factual basis for him being a homeless individual. So we just want to make sure that Mr. Carbo is monitored and that he stays away from the Waffle House. It sounds like getting himself into trouble over there. So,
okay.
Not further than say.
Thank you. Mr. York, happy afternoon. Can you share with me what you've got for Mr. Carbo's criminal history?
Yes, sir. I'm showing 24 cycles out of Georgia, but not showing any felony convictions. And then I have 21 out of Massachusetts. And I'm not seeing what the convictions are, but there's a couple probation violations reported, but I'm not sure what the underlying offense, well, no, I'm sorry, showing an assault and battery, but I don't know when the actual underlying offense took place.
Those are all Massachusetts.
They're Massachusetts. They're
probations?
from, the most recent though was from, I think it was 2008, so they're older. They're not current.
Okay. So are all 24 of Mr. Carbo's Georgia cycles from, we'll call it 2009 and forward, or was he in Georgia, then Massachusetts, and then Georgia again?
Let me find his first just to let you know for sure. Looks like it was probably in Massachusetts first and then Georgia, because the first cycle I'm showing for Georgia was a 2013 was the first Georgia offense.
Okay. And are just skimming them, are most of the cycles for things like trespass, disorderly conduct, or something along those lines, or are there cycles for murder and armed robbery?
No, most, let me see. There's a terroristic threat, so it was a decline to prosecute. The conviction for misdemeanors was theft by shoplifting.
Okay.
There's nothing major, not conviction wise here.
Okay. Perfect. That provides a helpful profile. Thank you.
Yes, sir.
So it sounds like, Ms. Tucson, you'll have no adult felony probation history out of Georgia for Mr. Carbo.
It looks like there is one, a 16 SC 142302. It ended in 1/23 of 2019.
Okay. And do you know what the lead offense was for that?
Obstruction of a law enforcement officer.
Okay. Got it. Okay. Thank you.
No problem.
Ms. Primovic, please tell me about your client and your thoughts about how we can keep him plugged in with the mental health support he needs so that he can avoid some of what it sounds like he's been running into.
Thank you, Your Honor. He's 33 years old. He said he's completed the 11th grade. He is from Massachusetts. He came down here when his grandmother died to try a new place. And he has found himself on occasion homeless. And this is obviously what situation this is. I spoke to him at depth, and so did Ms. Feely at the jail a couple weeks ago, about where he goes for his mental health. He says he goes to Grady. He said, I asked him if he had a specific doctor. He said, no, he just gets put on, whenever he goes in, he gets an appointment with the services there. He has a place to live with a friend in Decatur named Karen, but he also wants to eventually get into Georgia Works. He knows about that program. He has seen the people working. He does light construction and cleanup. He likes to work. He wants to work. He's a healthy young man. So he eventually wants to do that. He's been in for 7 months, Your Honor. We felt it asking him to go to misdemeanor probation, which is very costly and very pricey for Mr. Carbo, that it probably wouldn't help him with his issues, which is homelessness and drinking too much sometimes. And that's where his issue is. That night, he imbibed a little bit too much Southern Comfort, and he ended up at Grady with some taser wounds. So we're asking, Your Honor, for 12 months to serve, the 7 months commuted to time served, with the 5 months being suspended. And a condition of that suspension is for him to stay away from the Waffle House downtown. I explained to him where it was, because of that night, his memory was a little back and forth. He knows where the Waffle House is, and will stay away from it. And to let him go to Georgia Works and to complete and go to Grady as he needs to grow. He's well-spoken. He understands when we talk. He knew all about Georgia Works. I think he could take care of it himself. And in a more useful manner than misdemeanor probation.
Got it. Am I able to waive supervision fees for misdemeanor probation?
I don't think so. I think they're the private funded, I don't think so. I could totally be wrong, but we couldn't before.
Okay. What do they do? Is it then a indigent defendant on misdemeanor probation is in violation of probation because he can't pay the supervision fees?
It's not good.
No. Okay. All right.
It's a problem. I mean, it's pricey. I think it's $45 to $50 a month. It's not where you can say, $10 a month or $5 for felony probation. So.
Okay. Mr. Carbo, is there anything you want to add to the conversation we're having?
No, sir.
Who's Karen?
My friend.
How do you know Karen?
I met her when I came down here to Atlanta.
Say that again?
I met her when I came down here to Atlanta.
How long have you been in Atlanta?
About 9 years, 9 years.
Did you meet her way back when you first got here, or you met her maybe last year?
I met her when I first got here.
So you've known her for a while?
Yes, sir.
Okay. Why do you think she'll let you stay with her?
I stayed there before.
Okay. If you're staying with her in Decatur, how do you end up in the middle of downtown at this Waffle House?
I took the train, the motor.
What would you be doing in the middle of downtown?
Just hanging out.
Just hanging out. Okay. Where did you live in Massachusetts?
In Framingham.
Framingham. Any questions about anything?
No, sir.
All right. So, Mr. Carbo, I find there's a factual basis for your plea. I think that Mr. Jordan has done a good job of resculpting this case to reflect what it sounds like the facts are, that maybe you were passed out or at least a little groggy in or around this Waffle House. And at some point, it sounds like someone at that Waffle House had said, you can't be around here anymore. And then you and the officer didn't get along real well when the officer was trying to get you to move on, which is effectively what you're entering a plea to. So I find there's a factual basis for that. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, but after talking with Ms. Primovic, you've decided this is how you want to try to work it out. Is that correct?
Yes, sir.
All right. And a knowing plea is simply one where you've understood all the things we've been talking about. You understand the consequences, that I'm going to sentence you, that you can say no thank you to the sentence if I go higher than what your lawyer asked for, and that you'll have these misdemeanor convictions. Do you feel like you understand all that?
Yes, sir.
Okay. Then I'm going to accept your plea. Mr. Carbo, is it okay if someone on my staff signs your name on the indictment showing that you've entered a plea?
Yes, sir.
Ms. Primovic?
Yes, Your Honor.
And Mr. Jordan?
Yes, sir.
All right. So, Mr. Carbo, what I'm going to do is sentence you as follows, and hear me out, and then we'll figure out if this is something you want to do. First of all, how long have you been in jail? Do you have a rough feel? How many days?
Since July 28th.
July 28th. Okay.
Almost 7 months.
I think it was 209 days, Judge.
209 was your last. Okay. Okay. Yeah, that's very close to 7. So, Mr. Carbo, I'm going to sentence you to on count 1, which has been reduced to misdemeanor obstruction, to 7 months to serve. And you're going to get credit for all the time you've been in. And then count 2, which is trespass, I'm going to sentence you to 12 months of probation. It's misdemeanor probation. It'll run consecutive to the 7th. So you're going to be on probation for 12 months. It will be a condition of your probation that you continue to take all medicines that a doctor tells you to take, and that you continue to make all your meetings, your appointments at Grady, which is, I think, do you go to the actual hospital, or do you go to 11 Park Place, or do you go to both?
Both.
Okay, you're going to need any appointments. If you go once a week or once a month, you got to keep those up. And finally, if you enroll in Georgia Works and are in Georgia Works for at least a month, I'll end your probation. So if you get into Georgia Works next month, and you can do it for at least a month, and you can see, here's proof I've been in Georgia Works for 30 days, I'll end the probation. But as long as you're just talking about it and you're not really serious about it and you're going from Decatur to hang out in downtown Atlanta, then you're going to have to figure out how you're going to pay this probation supervision. And these probation officers are going to be bugging you saying, hey, what's going on? But if you want to be off probation, you need to get into Georgia Works, which I bet you can, and do well in it for about a month. And then you and Ms. Primovic or Ms. Feely can talk. And if they get me the paperwork showing that Mr. Carbo is in good standing with Georgia Works and has been doing it for a month, we'll make probation go away. Does that make sense?
Yes, sir.
Okay. Last thing, I forgot to add this. You're going to need to stay away from that Waffle House while you're under this sentence. So that's the Waffle House on Andrew Young Boulevard, is downtown. It may just be easier for you to stay away from all Waffle Houses, but that's not my requirement, is that you stay away from that one. Okay?
Okay.
Now, the sentence that I'm imposing is a little different than what you asked for through Ms. Primovic, because it does put you on probation for a little while. You can shrink it down if you are serious about getting into Georgia Works, but it's a slightly higher sentence because it does include probation than what you and your lawyer asked for. So if you want to talk with Ms. Primovic for a minute, you can, or you can just tell me, Judge, I'll take it anyway, but I want to make sure you have a chance to think about it, because now's the time to say, no, thank you. I'm going to stay in jail and wait for something else to happen versus I want to take this sentence. Do you know what you want to do, or do you want to talk to Ms. Primovic for me?
I'll take it anyway.
You'll take it anyway. All right. Then that's going to be your sentence. And what do we do about misdemeanor probation? Okay. So we're going to keep you up for a little bit longer because we may be able to get misdemeanor probation to come here just to get some basic information from you and let you know where you need to report. When you get out, you can stay with Karen, and you've got a real good incentive to go do Georgia Works. One, because you need it and it'll help, and it will help you break this cycle of all these arrests you've had. But two, it'll get you out of probation too. All right?
Okay.
Mr. Jordan, anything else? Ms. Primovic?
Your Honor, when he's in Georgia Works, would it then be suspended so those conditions would still be?
Yes. So I would turn your probated sentence into a suspended sentence, which is what your lawyer asked for. So you don't have to report to anyone, but all the conditions would still be in place, that you stay away from the Waffle House, but more importantly, you keep going to 11 Park Place, taking your medicine, that kind of stuff. Okay?
Yes, sir.
All right. Good luck.
Thank you.
Thank you, Judge.
Thank you for staying late.
Thank you.
I guess you had to stay anyway, Mr. Jordan, because this is your case with the motion. All right. Hey, I met your wife while you were goofing off in that other courtroom. She popped in for some fancy law firm and said, by the way, you may have heard my last name. I'm associated with Julian Jordan. And I said, oh, I'm so sorry for you. So she was very nice.
She told me it was a pleasure to have been in your courtroom, even though she's not staying on that case, but it was the highlight of her day.
I bet her virtual 3-minute appearance, bet she recorded it and plays it back repeatedly.
Yes.
All right, Mr. Bennett, do you need a little bit of time with Ms. Gonzalez?
Just a couple of minutes, Judge, to
Okay.
explain what we're doing here today.
All right, Mr. Lyles, good to see you.
Thank you.
As I understand it, all we're doing today is the constitutional speedy.
Yes.
Okay, because Crenshaw is somewhere else.
Is in Connecticut, I believe, so.
I'm gonna probably let Mr. York and Ms. Tucson go away. This isn't a case that he's gonna go talk to her about resolving it, or should we have him stay for 5 minutes?
There is a new offer on the table, Judge, and I conveyed it to Mr. Bennett just a few minutes before we came in, so I guess there's a possibility, but I believe that we're gonna go forward on the motion and still keep that offer open.
Okay.
Just want to make sure I got that right. 7 months to serve. On count 2, it's 7 months to serve on probation.
No, it's 12 months.
On probation.
Yeah,
That's consent.
consecutive, yes. So Ms. Feely will not be here tomorrow. Will you be covering the call of the calendar?
I am, Your Honor.
Fantastic.
I got notes and files, and hopefully we'll get things moving.
Drug court looks like it's going to be very short, so I will not be late for that. Sometimes drug court bumps up against that, but we should be good to go.
See you all in the morning.
All right, thanks for covering.
Actually, Judge, the state's recommendation, if Ms. Gonzalez were to take it as a straight prison sentence, so I don't know if probation or pretrial would be needed, to be honest with you. My apologies.
Okay, we'll have them stay just in case. When we come out, that'll be the first thing we cover.
Thank you, Judge.
All right, Ms. Rivers, are you ready? I'm going to swear Mr. Lares in. Mr. Lares, good afternoon.
Good afternoon, Judge.
Do you swear or affirm that you will interpret from English to Spanish and Spanish to English to the best of your ability?
I do, Judge, to the best
Thank
of my
you.
abilities. You're welcome.
Mr. Bennett, before we get started with your substantive motion, Mr. Jordan told me that he had extended a new offer to Ms. Gonzalez through you. And I just need to know if that's the direction we're heading, because I can release probation and pretrial services if what we're going to do this afternoon is handle the motion for speedy. But if we're instead going to resolve Ms. Gonzalez's case, then I need to keep those people on.
Yes, sir. We are in the process of negotiations. We're not quite there, ready to accept the offer yet today. I've been assured it will be kept open beyond the motions date, which I appreciate. So this time, I think it would be appropriate to release the judge.
Okay, I will do just that. So Mr. York and Ms. Tucson, thank you for being here this morning and this plea we did right after lunch. You guys are free to go, and I look forward to seeing definitely Ms. Tucson and someone from pretrial tomorrow at the call of the calendar. I think we're trying to start that at 1. Mr. Jordan assures me that it's going to be pleas aplenty. So we'll see you guys then. Thank you.
All righty. See you tomorrow.
Thank you, sir. Should have Ms. Jackson back for you tomorrow.
All right. Ooh, upgrading. Excellent.
Okay.
All right. Thank you, Mr. York.
Bye-bye.
Okay. Good afternoon, Ms. Gonzalez.
Good afternoon.
Mr. Bennett, you have filed what I'm going to call for shorthand, constitutional speedy motion. Your contention is that this not particularly complicated set of facts ought to have resulted in a trial, indictment and trial, sooner than it did. So I'm going to let you make your argument, and then I will hear from Mr. Jordan, and then I will take this under advisement.
That's right, Judge. And I'll lay out a little bit of the procedural history first. I suppose for the record, these are all facts that I think the state and I agree on, and judicial notice can be taken of them. Ms. Robles Gonzalez was arrested on August 4th, 2021. At her first appearance hearing, she was granted a $100,000 cash surety or property bond. I can represent to the court that Ms. Robles Gonzalez does not have the financial resources here in the United States or family members or friends that were able to pay that bond or negotiate with a bonding company to assist her release.
So August 4th of 2021 was the arrest date. Soon thereafter, she got a bond, but it's not a attainable bond for her.
That's correct, Judge.
All right.
On the 22nd of November of 21, we had filed a motion to reduce the bond. It was denied. On April 4th, 2022, we filed a motion to reduce bond again, which was again denied. And on May 27th of 2022, we were finally scheduled for a preliminary hearing in the case that was reset June of 2022 due to a witness availability issue.
So May 27th of last year was supposed to be the prelim. It didn't go forward. The state didn't have a witness. It got bumped to June. And at some point there was an indictment.
Correct. And in fact, June, we did have the preliminary hearing. The case was bound over.
When was the prelim?
Prelim was finally held on June 3rd of 22. And the reason I'm sort of belaboring this point is just to show that we made on the defense side efforts to move the case forward. We didn't actually end up with an indictment for another 4 months. So the case was ultimately presented to the grand jury 4 months after having been bound over from magistrate court on October 3rd, 22. But of course, the state could have obtained an indictment at any time prior to that. If I'm not mistaken, I believe the Fulton County grand jury was meeting at that time in 21, when the COVID isn't going to come into play here.
No, not by August of 21. I think there were grand jurors available. Not that it would have been presented on the day of arrest, but effectively it could have been if it went lightning fast.
Understood, Judge. I've seen that a handful of times, but not for a case like this. So finally presented to a grand jury on October 3rd, 22. And on November 2nd, 22, we were arraigned. I'm not sure how relevant this will be to the court's analysis, but I will mention running out of things to do on the defense side in frustration. We filed a motion to indict or release based on a little known Superior Court Rule 26.3 that authorizes the chief judge to take any action necessary or appropriate. The court's obviously familiar with that. It was denied.
Well, familiar with it only because of motions like yours. I don't think if you polled 100 Superior Court judges, 98 of them would have said, I know what 26.3 is. And I would have been in that 98. I have no idea. Tell me what 26.3 is. But of late, creative defense attorneys have pointed to that as a mechanism to try to move things along.
And it worked. I mean, ultimately, although the motion was denied, less than a month later, the case was finally presented to a grand jury. So I think the magistrate may have helped us out a little bit and maybe made some calls. I don't know what happened, but either way, finally presented to a jury, but Ms. Robles Gonzalez obviously was not released. The analysis is laid out pretty clearly in the motion. Greater than 1 year of pretrial incarceration is presumptively prejudicial, which triggers the Barker-Wingo analysis, and there's a 4-factor test here. First factor is whether the pretrial delay is uncommonly long, and certainly in my experience, yes, the 14 months to secure an indictment in a relatively non-complex drug possession case that has essentially no more than 3 witnesses that are all law enforcement witnesses is uncommonly long.
Is it your experience that in any particular jurisdiction, but we ought to focus on Fulton because that's where we are, that there are multiple tracks for indictment so that somehow there's a screening mechanism for the district attorney's office to say, this is a simple case, let's indict it sooner versus this, ooh, it's an armed robbery charge, it must be complicated. Obviously, there's an exception if it's a multi-defendant gang murder,
right?
But taking that out of our assessment, what's your experience that a shoplifting case will move faster through the indictment pipeline than a drug case than an armed robbery?
You know, I think, frankly, Your Honor, if I'd probably be able to answer that question better if I'd ever worked for a district attorney's office. I've only ever been a defense attorney. However, in my own experience, yes, certainly the more complex the case, the more time it will take for the state to decide which charges are appropriate. The more time it will take for the state to present witnesses to the grand jury. I would certainly assume that to be the case without having firsthand experience.
Well, but you have firsthand experience on the receiving end. I appreciate you've not been in the sausage making part of things, but you get clients who've been indicted and you're able to look at it and say, gosh, you had to wait for a year to be indicted. And I'm only poking a little bit because I think there are, in my experience, and it may not matter for the analysis, and that's where you could really push back. But there's sort of 2 buckets. This is kind of complicated case, and it could be a white collar case. That's complicated. A murder case, a gang case, a interfering with a 2020 general election case.
Right.
There can be a lot of time spent investigating before indictments are brought. And then there's everything else. And I think in that bucket includes armed robberies and aggravated assaults, for which you only need 1 witness to get in front of a grand jury, a police officer, to summarize, here's what happened, and we recovered a gun from the person and someone was shot. But in some ways, that's a whole lot more complicated than this. You might need to have a doctor testify and an EMT testify and the 3 eyewitnesses and 4 officers, but it sits in the same bucket as this case.
Right. And
so what was uncommonly long about this versus every other case?
Right. The uncommonly long, what was uncommon about it to me was the 14 months, Your Honor, frankly. I mean, in a drug case, I practice a lot in Gwinnett County. I got cases here as well in Fulton County. I'm not usually waiting more than 90 days for an indictment, even for a client that has a bond. And honestly, I think that what probably happened here is it went in the bond bucket.
Mm-hmm.
And the assumption was made that because Ms. Robles Gonzalez has a bond, it's a bond she can make, or that it doesn't, it's deprioritized to avoid missing that 90 days. So I think that's probably what happened here. And because Ms. Robles Gonzalez doesn't have the financial resources, that caused her to be maybe improperly put in that bucket. And that resulted in her pre-indictment delay being uncommonly long.
Got it. What's number 2?
Number 2 factor, Judge, is who's at fault here. At the point in the process that most of this delay occurred, the state was the only actor with the ability to move this case forward. Short of me, filing repetitive motions for bond that were repetitively denied, short of the defense filing some kind of petition for habeas corpus or mandamus to try and compel the state to take the case to the grand jury, there was nothing we could do. So I would submit that factor should be weighed heavily against the state. Certainly the first factor should also be weighed against the state. But the second factor, we can't fault the defendant or the defense at all here. We did everything we possibly could. The other piece of this, I was going to mention that 45-day notification requirement, whether or not that was complied with by the state, I'm not sure that really would have made a difference for the analysis, but it could be probative of their attention to unindicted cases if that requirement was not followed. And I don't have any evidence, obviously, to prove negative that it wasn't, but I will rely on the state to possibly present that if, and there doesn't appear to be any other rule that really constrains the district attorney's office in terms of when they can bring an indictment for a grand jury under the statute of limitations. So.
Right. Or something like this, the corrective mechanism of you waited too long and because of the other factors, these charges are dismissed.
Sixth Amendment. Exactly, Judge. That's our final stop here. The third factor would be assertion of the right. Here, the defendant asserted the right at the earliest opportunity she had, which was the arraignment hearing. I would suggest that the record, if we look, would also reflect that attempts were made to bring attention to the fact that this case was lingering at each motion to reduce bond, as well as during the motion to indict or release hearing that I'd be remiss if I didn't mention that no one from the district attorney's office actually showed up to that hearing.
So this was an argument in front of whom?
It was a magistrate judge, Your Honor. It was Judge
Drake?
Yes, I remember her old last name. It was Judge Drake. That's correct, Your Honor.
Okay. What was it that your client asserted at her initial appearance? You said at the earliest moment she asserted something. What?
Right, Judge. Actually, the earliest moment post indictment, I suppose.
Okay.
Could it have been asserted at first appearance? I guess theoretically, yes. But I don't.
You meant her first appearance here?
Yes, sir.
Okay.
The first appearance before Your Honor at the arraignment hearing on November 2nd of 22 is when we invoked constitutional right to a speedy trial. And I remember the court asked me whether we were filing a statutory speedy demand, which has to be in writing, or we're simply invoking the constitutional right. And I, explained that it was only the constitutional basis at this point. So I'll move on to the fourth factor, Your Honor, which is prejudice to the defense. The three purposes of or the analysis here, I suppose, would be to prevent oppressive pretrial incarceration, minimize the anxiety and concern of the accused, and to limit the possibility that the defense will be impaired. And here, of course, because of the greater than 1 year timeline we're working with, prejudice is presumed. And based on the cases I've looked at that are somewhat recent, it does appear to be the case that the state burden sort of shifts to the state to prove lack of prejudice under this particular circumstance. So,
well, I think there can be a presumption that incarceration becomes oppressive. It's never a good thing. And anxiety, although my recollection of the case law is that it needs to be anxiety beyond these charges are hanging over my head, or jail is a stressful place to be. If I'm going to consider that as a separate factor from being in jail for a long time.
Sure.
And then the third is you need to show that evidence has been lost or witnesses. And I'm not familiar with case law that says the state has to prove evidence wasn't lost. The state could say, we're ready to go forward. So
some of this is a little dicta-ish, Your Honor, and these are Court of Appeals cases. And, I don't think it would be fair for me to bootstrap the presumption of prejudice to say, oh, automatically a year, because the case law also says, no, that's not how this analysis works.
Right.
So your point is well taken, Your Honor. I still think we get there here when the oppressive pretrial incarceration, the case law mentions that the greater it is, the more, it doesn't automatically trigger the prejudice, but it increases it. And here we do have plus 1 year. I can proffer to the court that my client has some pretty significant medical issues that add to the anxiety of incarceration. Specifically, she suffers from a ruptured eardrum that is the result of a domestic violence incident with a former husband. And at least 2 occasions when I visited her in the jail, she's been bleeding profusely from her right ear. I believe she's obtained adequate medical care at the jail, not necessarily the best possible care she could obtain. And that's something I would ask the court to take into consideration. In terms of prejudice or damage to the defense in this case, there is an issue of witness availability. Of course, the witness is a law enforcement witness, which, you know, could possibly cut against my argument. You know, unavailable witnesses can sometimes be helpful to the defense.
Is this former Officer Crenshaw you're talking about, or there are others who have moved on?
I believe it's just Officer Crenshaw, although at the time of the prelim, my recollection was that the lead GBI agent was gone. But is that still the case, counsel?
That is correct.
Okay, so there's a lot of people that have sort of dissipated from Fulton County and Georgia in general that may have had exculpatory information. I can speak very briefly about the facts as I understand them. This was a controlled buy set up by the GBI. The person who they did the deal with showed up at a parking lot and handed a box to Miss Robles Gonzalez. Miss Robles Gonzalez was arrested. The box was in her car. It had drugs. The person who handed her the box was driving a pickup truck, got away.
Got away or was allowed to drive away?
Could very well be he was allowed to drive away, Your Honor. And I suspect that this controlled buy may have been with this individual as the informant, which is certainly possible, but we're never, you know, I haven't gotten a straight answer on that. And, you know, it is what it is. That's the facts. Now,
sure.
My client has no history here that I'm aware of, no criminal arrest history, has maintained that she was not aware of what was in the box. Now, whether that's going to be deliberate ignorance instruction territory on a drug case, we may end up there, depending on whether she testifies or not, and then depending on whether I could obtain exculpatory information from the investigation. They're not exactly free and easy with giving us discovery in these cases for obvious reasons. But Your Honor, I would suggest in this particular case here, all four factors should be weighed against the state. She's been in custody for about 1.5 years now, and I would ask the court to dismiss the case. There was no urgency then, and there's really no urgency now, Your Honor.
All right, Mr. Jordan, give me 1 second.
Yes, Your Honor.
Okay, state's perspective.
Thank you, Your Honor. First, I wanted to say that Attorney Bennett was correct in the procedural history, at least from my review of the file.
Those dates, you don't disagree with any of those dates?
I don't dispute any of those dates, Your Honor. And I actually also agree that it may have been a situation to where, since Ms. Gonzalez was given bond pretty much right away or the day after, that it may not have met the track in which it was going to be the quickest and fastest indictment, Your Honor. The state's argument in regards to this particular motion, especially as to prong one, and it's an unfortunate reality of being here in Fulton County, is that the state would assert, especially with the backlog of cases that we do have, is that the delay was not uncommonly long. I see many trafficking cases from 2020 that are still unindicted, 2019 and prior, that take multiple years to get indicted. So it is unfortunate for Ms. Gonzalez. I'm not trying to mitigate any of the feelings that she's had while she's been in custody, but the state would assert that the delay was not uncommonly long, especially given for Fulton County, for the amount of cases that we have, and for the amount of time that it was indicted in. The state would assert that it was not an uncommonly long time for it to take 1 year for it to get indicted. Your Honor, for as far as who is to blame for the delay, we understand. I wouldn't make the argument that Mr. Bennett would be in a position to be in blame for the delay. The state is in charge of indicting its own cases. Your Honor, I'm glad that we talked about prong 3 because of course I was not present for the plea and arraignment. I think that was when the previous ADA was handling the file. So I was not made aware that defendant had asserted their right to the constitutional speedy at the earliest moment possible. One of my arguments was going to be that this motion was untimely, given that it was 10 days after the, longer than 10 days after the plea and arraignment. And there is a motion to file additional motions that I did not see if there was an order that was signed. But given that Attorney Bennett has proffered that the right was asserted early on, at the plea and arraignment, the state has no argument for as far as whether the defendant in due course has asserted their right to a constitutional speedy.
So you're clear. I don't have a specific recollection that happened. I'm not doubting Mr. Bennett. In terms of the timing of the motion, though, I'm going to look the case up right now. As you do know, even if you weren't at that particular arraignment, the rules in this division are that 10 days doesn't apply. I explained to the lawyers at arraignment, great, you're waiving arraignment, or I'm formally arraigning your client. What's going to happen next is that a scheduling order will go out, and that's your deadline for filing motions. So I don't think by that document, I'm pulling it up now, by that scheduling order, the motion was untimely.
Yes, sir.
But it does affect things as to where it was filed. It wasn't filed. Let's get the docket up here. So um, 4 days after indictment, there was, it's like it when lawyers do this, filed a rule nisi, as if I'm going to suddenly set down this hearing because they filed a rule nisi on the motion to indict or release. So it kind of went to the wrong judge because it went to me and it's addressed to me only because she'd already been indicted. But I'll view that as an indication of the defense team saying, look how long this case has been around. And
llevándole el caso a este juez. Dice por eso que este caso está ante mí, que está ante un buen juez.
Oh, so I see. So the actual plea and bar or motion to dismiss wasn't filed till December 1, which was, we'll call it a couple months after arraignment or whenever it was. No, it's only a month after arraignment, but it would have been within the window that I prescribed through the scheduling order.
Understood. Thank you, Your Honor.
Okay.
In Your Honor, I believe that was to prong 3, that defendant has asserted their right to a speedy trial. Your Honor, and the state would assert that there's been no suffered prejudice as a result of that delay. While we understand no one wants to be in custody, that and we understand with the full knowledge and the understanding that we have requested a continuance again today for the motion to suppress because an officer was unavailable, that this is a particularly simple case as far as the amount of witnesses that could be had. The GBI drug lab, which I believe Attorney Bennett does have, that the prejudice would be those particular items getting lost, or if anything, Your Honor, this delay, because the officers are now all in different places, affects the state more so than it affects the defendant. And Your Honor, Attorney Bennett also was pretty much clear when he got into the facts of the case. The state would just assert that this was a large, I believe it was 990 grams of the particular drugs that were found in Ms. Gonzalez's trunk, that we believe that each step of the way, though it may have taken a little bit more time than Attorney Bennett has liked and Ms. Gonzalez would like, that she's had a probable cause hearing, that she got her bond within the 90-day period, that the case has been indicted within the 4-year statutory period. We would just ask, Your Honor, that this motion be denied. We would assert that beyond prong 2, which absolutely would be the state, would be the blame for the delay, that prongs 1, 3, and 4 are those factors. All should not amount to a dismissal of this indictment. Your Honor, the state is ready to proceed for the motion as long as we can get Officer Crenshaw in. But we do want to both of the GBI agents, I believe GBI agent McPhee and also GBI agent Rhett are in different locations now. So
Are they in the United States?
they're all in the United States, Your Honor. They just work for different agencies. So,
Okay.
but we will, if this case proceeds forward to trial after the motion is suppressed, given if Your Honor does not suppress the evidence, the state is ready for trial. And whichever calendar that Your Honor places it on, the state will be ready.
Okay. What is your understanding of Ms. Gonzalez's status in the United States? And linked to that, if she may bond, would ICE just be waiting for her because of the nature of these charges, so that this notion of if you just let me out, everything would be okay isn't entirely accurate?
Your Honor, I understand from Attorney Bennett that she is undocumented, and I believe, and Attorney Bennett can correct me if I'm wrong, that she will still be held until ICE comes and picks her up. Is that correct? Even if she is.
I'm gonna ask him the same question. I wanted him to get everything out and then see what your perspective would be, because a perspective could be, this is all fine and good. The argument about the extensive incarceration, but the notion that if only the bond had been lower or the indictment had been sooner, this could be resolved and Ms. Gonzalez would be free to return to family, get better medical care because she'd be out. That may not be the full picture. If in reality she would remain in custody and potentially go to an ICE detention center, and any basic understanding of the media coverage of ICE detention centers suggests maybe Ms. Gonzalez has been in a better place here in Fulton. That just changes the prejudice analysis. It has nothing to do with, did the state take too long, factor 2, and well, who's at fault for the delay? And I appreciate your candor on that. And whether it's uncommonly long or not, that has nothing to do with whether Ms. Gonzalez would in fact be at complete liberty if this case were to go away by judicial fiat or a plea or whatnot. But I think it does affect factor 4, which is why I was asking you.
Absolutely, Your Honor. My apologies. Attorney Bennett and I are very well aware of that, which is why we've been trying to reach a negotiated resolution in this case. I wasn't sure if that was appropriate to bring up, but I do understand that.
Well, now I've asked, so it's appropriate.
Yes, Your Honor.
Okay. All right. Anything else you want to add?
Nothing further from the state judge.
Okay. So Mr. Bennett, you should respond in any way you want, although Mr. Jordan has mostly said Mr. Bennett's right in his presentation. But come on up and start with, please, Ms. Gonzalez's status and your understanding of what would happen if tomorrow I dismiss the charges or tomorrow she pled guilty, and what that means.
If the charges were dismissed, ICE would have 48 hours to pick her up from the Fulton County Jail.
They have a detainer on her.
I have not seen a detainer that has been lodged. What's lately been happening is, under certain circumstances, the sheriff's office will call ICE. I believe in hers, they likely will, because she was arrested at the border at one time.
Okay.
So I think they've got an alien inadmissibility notation on her criminal history that would result in a call to ICE. And given the severity of her charges, I think it's likely there would be a van waiting for her.
But it's not as black and white as, yeah, actually there's a detainer. So it doesn't matter what the sheriff does. The holding mechanism is in place. It would require affirmative action by the sheriff's office to get ICE involved.
And further affirmative action by ICE to lodge the detainer request.
Sure.
Send someone here to take her into custody.
Okay.
So I've had folks get released out the front door, and I've had folks get picked up by ICE. It's a crapshoot.
Okay.
And
but you agree that based on an arrest at the border and the nature of these charges, it wouldn't be odd for the sheriff to make the outreach and ICE to say, yes, we'll put a detainer on it.
No, it would.
Okay.
And I will also represent that at the point, assuming that that did take place, and she was deported to Mexico, she would still have her liberty. And, you know, the pretrial incarceration aspect of this is still prejudicial regardless of which side of the border she ultimately ends up on. She does have family in North Carolina. She's essentially what I like to describe as a migrant worker. She comes here, she mostly cleans houses and does construction work, a lot of different jobs, and she sends money back home to her town, which is a indigenous community in Jalisco State, I think, and it's called the Yalapa community. And that's where she's from. It was annihilated by a hurricane back in 2019, which is what resulted in her coming up here to find work and wire money back home. But I would suggest prejudice still goes in our favor, Judge.
Okay, got it. Anything else? No, Mr. Jordan.
And Your Honor, if I may, I do, if I can show it to Attorney Bennett as well, I do see a immigration detainer from August 5th of 2021.
Didn't show up on
That would make sense, given the way this deal went down and who got arrested and who didn't. I'd be surprised. I would have been surprised to know that there was no detainer soon after arrest.
Yeah, my mistake, Judge. It didn't show up on the jail and on the publicly accessible.
He's got super secret access.
I can see that. And I can send that to Attorney Bennett following.
Okay. But that doesn't change the only thing it changes is it doesn't require the sheriff to do something and then ICE to do something. ICE has already done that something. Your position that were these charges dismissed or otherwise resolved tomorrow, Ms. Gonzalez would shift to ICE custody, but ultimately upon removal, deportation, whatever the verb would be, she would be at liberty in Mexico, reunited with family and whatever's left of the town that was hit by the hurricane.
Yes.
Okay.
And she would understand that returning to the United States under these circumstances would be result in federal prison time.
Could indeed. Yes. Okay. I will take this under advisement. My thought is that we get this case on a trial calendar, and worst case scenario, we would do the suppression hearing. Crenshaw would have to be here for a trial anyway. And so we would do the suppression hearing then. That would effectively be the trial if the drugs are suppressed. It might be the trial if the drugs come in, because that might then yield a plea. If there is an offer that's been made pre-suppression that's being seriously considered, it sounds like ruling on the suppression motion is going to clear the decks on this one. So my thought is, rather than do a two-step process, in case I deny the motion, let's at least get that trial ASAP to address. These are all valid concerns. It's just a question, do they rise to the level that they need to be remedied by dismissal of the charges? That's an extreme remedy. It's justified in some circumstances, maybe these. But if I don't find that, I certainly want to get Ms. Gonzalez back in court for resolution one way or the other.
I think we were on a calendar March 15th. Right?
Yes, Your Honor. I believe that was the next scheduled time, was March 15th.
For the suppression hearing, or it was on a trial calendar?
It was on for status, I believe, for March 15th.
Okay, well, I'll work with Ms. Nelson. Status would have been to make sure you've got all the discovery. You do. Are there any outstanding motions? There are. And then we'd still need to do the suppression hearing. So I'm going to try to accordion all this into, let's get a trial date, and leading into that, let's do the suppression hearing. And so we may skip the status hearing unless you tell me now you've got concerns about discovery, Mr. Bennett.
No, sir.
All right, I'm gonna call this our status hearing as well. We're not waiting on the crime lab or anything like that. I have one other matter, and then you let me know, Mr. Bennett, if you've got anything else. On October 7th, in this flurry of activity, filing the rule nisi, et cetera, there was a demur filed.
I meant to withdraw that. I'm going to go file that withdrawal today.
Great. I assume so. It was let me just get this in place, because that is one of those few motions where it's waived if you don't file it within 10 days and you were just receiving information about the case. It wasn't ever particularized, which said to me, when you did have time to study the indictment, there were no demurrable issues in the indictment. Okay.
That's correct.
Sounds good. Anything else on behalf of Ms. Gonzalez, Mr. Bennett? Mr. Jordan, anything else for the state?
No, Your Honor.
Okay. Then I think we are all set. Ms. Gonzalez, it was nice meeting you.
Gusto en conocerla.
Igualmente.
Similarly.
Okay,
Dios lo bendiga.
God bless you.
okay, you too. Mr. Lares, thank you for your services. All right.
Just 2 minutes. May I be excused, Judge?
Yes.
Okay. Kiss and you got it.
All right, I'll look at Carbo. You're still doing Adams. Great.